Maybe. But in item number 4 listed today, I have filed uh, interlocutory applications.
Hmm?
Two interlocutory applications, my lord. What happened in this case, my lord? There is a interim order restraining demolition of third floor. That interim order has been vacated. Now the writ petitioner, we are the, my lord, temporary occupant of that floor. We need some time, ma'am, to get ourselves seated. We are not going to.
Who are you?
I'm the tenant, tenant of the writ petition.
Tenant has no right.
No, I do not claim any right, my lord. I do not say
You
anything,
and the matter reaches.
lordship. I, I, I have filed, my lord, to IAS, my lord,
When did you file?
yesterday. Lordship. Lordship.
Concern listing of a new writ petition, Lordship, it's a tender matter where I have been disqualified, but till date the tender has not been finalized.
Tomorrow?
Lordship, it was filed on 31st, but till not reported. Tomorrow, much obliged.
May I please, your lordship. I'm praying for listing of a tender matter. Tomorrow, lordship, I have
Which one?
motion, lordship.
Lordship on admission matter. I am for listing net admission. Admission for what?
Lord, the matter pertains to compensation of sick. My lord, the petitioner's husband died due to COVID-19, my lord.
When five?
Lordship, please, Lordship, it's a tender matter with a similar matter with.
Please, this is for listing for admission, my lord. Admission, my lord.
Matter pertains.
Matter for Jimma, related to Jimma of kettles, my lord. For Friday, man. I'm of that.
May it please the lordship. Lordship, I am praying for listing of a writ petition for motion on tomorrow, my lord.
Listing the AI for admission. AI for admission.
For what?
Insurance claim. Insurance claims.
Huh?
Insurance claim.
Insurance?
Claim.
Claim. MSCT. What am I going to do in a writ petition? It's a writ petition.
Lordship will file AI. Lordship will file.
Is it a writ petition?
Yes, Lordship. Earlier we filed writ petition.
INW petition.
Write it.
Lordship, I have similar pair.
What?
I have similar another pair, contempt case for order.
For?
Order.
Order for what?
Hospital authority are not contempt case for order. Hospital authority are not.
Contempt.
Yes.
Okay, next Monday.
No, my lord, item 1.
There's another one. Oh,
May I appeal, Lordship? We are for listing, Lordship. Read petition for motion, Lordship.
tomorrow?
Day after tomorrow.
Not day after.
Friday, Lordship.
Right.
Let's.
Please, your lordship. Lordship, senior counsel Bhima is on legs.
Who?
And Bhima, Bernali Bhima is on legs, lordship, in some time. And
Take it out.
oblige, lordship.
Tomorrow.
My lord, we have complied with it.
Right?
Handed over, position has been handed over.
So, now we, as it has now been complied with, we close this proceedings, including the proceedings before the.
Trial court.
Same number is going on there, my lord.
There is another, my friend said that there is another execution also.
Certainly execution is also stayed there. Not certainly.
So all these things, we close it on the basis of it has been complied with. And have you been, what is the amount now you are being paid?
Amount is already paid, my lord.
No, that amount is there, but this period,
That has not been quantified, my lord.
why? That is the last quarter part.
And that
How
I
you
understand
comply
that
with?
we have seen, my lord, what, my lord, what we are sincerely praying, my lord.
If lordship passes an order, then it will be, it helps us.
Then it is an illegal possession by you.
No, my lord, if,
Then we can't close that. Let the criminal proceedings go on. They can only be handed over,
That
but
not
remaining,
9%,
if
9%,
you don't pay
my
that,
lord,
then
that period, my lord, that is, one difficulty is on our part is,
no, during the pendency of the writ petition, yeah. During the pendency, you have in possession of that earlier order which was passed out there. Was the directive file with you? Item 1. In
La-
addition, the petitioner shall also apply to scope whether for the period during the pendency of the present proceeding, any amount has been qualified for payment to the respondent for use and occupation of the land by the
my lord, from that, that period, my lord, that if lordship specifies.
Okay, I give you the date. The date I have given you when you have filed during the pendency of the. You have only paid that amount.
My lord, lordship will consider, say, ASCC, my lord, say,
2021, for 4 years. No, there is a reason why. The state authorities should be more careful.
I understand, my lord.
Mr. Somua, yesterday there was one matter.
Well.
Your managing director had renewed, given a renewal without following tender process under his signature. And now you realize that when the court passes an order, then you realize, oh, there is no tender process. How
It
did-
was in 2018, my lord.
No, that was done in 2024. 2018, initially you gave him
Yes,
the
yes.
tender.
That we have
Thereafter-
admitted that this is a mistake. my lord.
Thereafter, for the period of 2-3 years, then you have increased.
This present MD, my lord, joined in 2024.
Under he,
Yes, we
it is
admit
in
that.
his signature this has been done.
Yes, we admit that. We admit that.
If
That
you-
is why immediately
if
it has
you-
been,
You see, we are concerned as regards the ASTC. We have a well-being for the ASTC, taking into account that it has served the state of Assam for many years.
yes.
But that doesn't mean that the ASTC is going to do something to that effect.
But what I sincerely pray, my lord, if lordship takes us as a lenient view, my lord, so far as this
What
quantifying,
is lenient view about the ASTC? Yes, additional advocate
Basically,
general.
Lordship, they are officers, Lordship, and whatever delay occurred, Lord, it is not because intentional, Lordship.
Why? Because the matter was pending.
No, matter is pending.
There was an undertaking given from long time.
Yes, that is there, Lordship, but Lordship will consider. They tried their best, Lordship. On 3 occasions, they floated tender, but nobody came forward. And that is the only reason, Lord. And Lordship will also consider this is our petition. not
That is why. It is a continuation of that proceedings.
Lordship.
It is his petition. We are considering out here in the exercise of 227. You have to understand that. What do you say, Mr. Pukan? Are you going to give by all this period?
no, my lord, I have not inspected like this, my lord. Because the SEC was dated 27/6/2025. Up to that, they have paid the amount. And this amount is
27?
27/6/2025.
So beyond this period, are you going to, taking into account now you have got back the land, are you going to keep it? Okay,
4 months.
forget about it. Are you going to keep
No,
up?
no, it is up to the honorable.
They are not pressing, Lord. So Lordship will consider one, ultimately, Lordship, one criminal aspect is also there. Lord.
No, because I am doing that criminal matter. I will not proceed
Yes, Lord.
with the criminal. So they have to pay this compensation, my lord, as per the order.
He cannot say that he is not, because once it becomes a criminal proceedings, then it is end of the, means it is beyond him. So by an order passed by this court, the criminal proceedings also has to be put at rest.
No. Court may consider a lump sum amount.
When did you file the matter?
This 2014,
Huh?
no,
Yeah, but সিহঁতৰ case নাই।
It's আগত।
The case is 2014.
That matter is of 2014.
Hmm?
Case
The
is
land grabbing is of 2014. And the amount that has been quantified by the judgment, that we have paid along with interest.
They
Therefore,
paid along with interest.
Interest. That is why we are paying
9% interest. So
9%.
Paid with interest. So I think, Mr. Fukon, I think we can close this
my lord,
Huh?
my lord.
as we've got that. Mr. P. Nayak, the learned Additional Advocate General, Assam, as well as Mr. A. Somwa, the learned Standing Counsel of the Assam State Transport Corporation, who appears on behalf of the petitioner, and Mr. E.C.C. Fukon, the learned counsel who represents the respondent. The present proceedings under Article 2 to 7 of the Constitution is directed against the judgment and order dated 18/3/2021, passed in Session Special Bracket Land Grabbing Case Number 02/2014, whereby the learned Special Tribunal Land Grabbing, Morigaon, had, by a detailed judgment and order, held that the petitioner respondent herein had right, title, and interest over the suit land and entitled for recovery of vacant possession of the suit land by evicting the petitioners herein and any other person claiming to them, and by demolishing all constructions made over the suit land by the ASTC authorities at their cost. In addition to that, the learned tribunal, special tribunal, also held that the petitioner and respondent herein would be entitled for compensation of rupees 5 lakhs from ASTC, Assam State Transport Corporation, within 3 months, failing which the amount shall carry an interest at a rate of 9% from the date of the order till realization for illegally possessing the suit land. Full stop. It is noticed that pursuant to filing of the present petition, the learned coordinate bench of this court by an order dated 28/2021, while issuing notice, state the operation of the judgment and order dated 18/3/2021, passed in Session Special Bracket Land Grabbing Case Number 02/2014. The stay order thereupon continued from time to time till the same was vacated by this court. Till 22/7/2024. During the pendency of the instant proceeding, certain developments have happened whereby the ASTC, the petitioner, more particularly the petitioner number 1 through its managing director, gave a commitment before this court that the possession of the suit land would be handed over to back to the petitioner, a respondent. And further, the amount with interest as directed by the tribunal, special tribunal would be paid to the petitioner, a respondent. It is further noticed that the said amount so directed by the special tribunal along with interest amounting to rupees 6,85,918 was duly paid to the petitioner as is apparent from the records. It has been also submitted at the bar that the possession of the land have also been handed over to the respondent herein on 10/11/2025. And the respondent presently is in possession of the suit land. This court further takes note of that it is further, it is also the submission of the learned counsels at the appearing on behalf of the petitioner party that taking into account that the petitioner number 1 is a corporation, is a corporation, is a company of the state of Assam. And on account of certain and on a company of the state of Assam, and the proceedings initiated being a land grabbing case number so and so, be closed, taking into account that the petitioner, a respondent herein, is satisfied with the handing over of the possession as well as the payment of the amount as directed by the learned special tribunal. Considering the above, and more particularly taking into account that the petitioner number 1 is a corporation of the government of Assam, this court is also of the opinion that the further continuation of the special land grabbing case number so and so would not be in the interest of justice. Accordingly, the instant proceedings therefore stands disposed of with the following observations and directions. This court confirms the order passed by the learned special tribunal, judgment and order passed by the learned special tribunal, dated so and so, passed in special case number so and so. Number 2, the payment of the amount of rupees 6,85,918 to the respondent and the further handing over of the possession of the suit land to the respondent during the course of the instant proceedings would be deemed that the judgment and order dated so and so, passed in so and so, is duly satisfied. Number 3, taking into account, this court further directs that on account of the taking into account the interest of justice, the further continuation of special land grabbing case number so and so on the criminal side would not be in the interest of justice, and accordingly by this present order, the said proceeding stands closed. This court further directs,
One exception that
that is what I am. In addition to that, हे ऊपर देते আমি satisfied bill लिख लूँ ना, in that view of the matter, satisfied or local, in that view of the matter, the execution proceeding being case number, what is the case number?
my lord, case number is title execution 2/2021.
Also stands closed. It also, its special event is closed, and the learned special tribunal, land grabbing tribunal, Morigaon, on the basis of the instant order, shall act thereupon. There shall be no order for further costs. Records be returned to the learned special tribunal.
For admission item 2.
Mr. Somu, I'm keeping the ASTC in the blacklist. Next time it should not happen.
I apologize, Vlad. What best I can do with that, I can apologize.
You did it, but the thing is, next time it should not happen. You are ask your ASTC to be more careful
Man,
in trespassing into
well,
somebody.
well informed. But what happened, actually, this, I have seen the inside the administration. To be very frank, nobody has taken care. Nobody has taken. Everybody comes, the managing director is an SES officer, always. He comes for 1 year, then he goes, then again someone comes. That is why.
All institutions, even the High Court have functions in that. Yes. Item number 2.
Lord directing my lord, the amount, my lord. The DC has my lord sanctioned the order and my lord, and calculated by with interest, my lord, but he pays for his time, my lord. He has.
Or
taken-
payment,
For payment, my lord. For payment. Lordship of the payroll, my lord.
have you provided the head of accounts?
My lord,
Have you provided the head of accounts? I'm asking her.
My lord, he has-
Head of account is there. In this regard, the sanction
Yes.
proposal for payment. No, not this head of account I'm asking. I am asking the head of account of that,
my-
of the district.
Yes, yes.
Where is that?
Head of account number 2.
His sanction order, if he passes a sanction order, would not do. You will say tomorrow that you don't have the money.
The letter, my lord, this mentioned, my lord, head of account 2235.
No, this is only for the sanction proposal.
My lord,
The sanction proposal for payment under head of account has already been placed for the revenue and disaster for the necessary. However, the process of sanction is presently under consideration. Some additional time is required to complete the formalities, and payment will be made as soon the budget is received. I'm not concerned.
my lord, but later,
You have not provided a,
later,
by 2 o'clock, provide the head of account. We should attach the head of account.
my lord,
We are not concerned, madam, we are not concerned with all these things. This particular Dhubri district commissioner's account has to be frozen till the payment is not.
my lord, 15
You
days.
have people in the establishment who can,
15 days, my lord, last paragraph, he pays for 15 days, my lord.
no, there's nothing mentioned out there 15 days.
If my lord, one,
Where is the 15 days? At least speaking here for making payment in compliance with the order stating that the sanction is under active consideration and payment is so and so. Can't happen like this.
head of,
my lord, 1 week time will be granted, my lord, so that, my lord, he can try. his
Payment
best, my
has to be made. You see,
Yes,
these,
madam.
we are concerned with these people who are, these are workmen compensation dues. It's a sad state of affairs.
My lord, 7
Government has, government has, district administration, they have these disaster management funds now. From those head of accounts, give us the money. And pay.
7 days time, your lordship will be pleased to grant, my lord. I'll inform him that in any case, he is to pay a 7 days time, lordship, which then my lord, I'll not pay him.
What work these people did?
my lord, they were daily wage workers, my lord, daily wage workers.
For?
Laborers, my lord.
For?
They were excavating some area, my lord, for.
Under the district
under the
administration.
district.
So money has to be, You are finance? Who is to make the payment?
Sir, as I have understood, disaster management,
Where is the revenue?
additional chief secretary, lordship will find later dated 10/11. From the Assam Revenue and Disaster Management District, 6 payment before considering the legal obligations arising from honorable Gautam High Court order, I have now honored to submit farm demand for an amount of rupees 19,67,504 and request you to place the budget allocation at the earliest to furnish.
You have only woken up and given this letter only when? 10/11, 1 day before. So? I passed the order on 29/10. Long time.
He has sanctioned on 31st of October.
Sanction has no meaningful purpose. These things won't happen.
Around 7 days that.
Yes, revenue. Get hold of a revenue council. Get hold of a revenue council, we pass the appropriate order. Directing the revenue also. They are also responsible. Otherwise, ask the head of account from the revenue and tax. Once we do that, then only. Madam, you wait for some time. We'll get your money before the end of this month. Thousand 22, these people are fighting. My goodness.
Item 3.
They have been fighting from 2014. Yes, madam, what is this? Wait, where is the other matter? Where is Mr. P. Bhuya? Miss P. Bhuya, the other,
Yeah.
was at the top of the list. Anyways, okay, Miss Silence, and take care, tell me. What are you challenging?
Challenging, my lord, once,
All
my lord, this
subsidy
is the second
matters.
round of litigation. First round, my lord, petition was allowed. Then they have passed, instead of giving the relief, they have passed a speaking order. Then I have to say, file this second writ petition.
What are you challenging?
Challenging the speaking order, my lord.
Is that
Earlier, my lord, as per my lord, the guide, scheme, that is
where
at
is the
page
speaking
32.
order? Page,
Page 32. Page 30, your lordship, is the
Page?
first market. Page 30 is the my lord, guidelines for implementation of national mission food processing on food processing for the 5 years plan.
no,
my
madam,
lord, 13 to
which
17.
order are you assailing?
Exactly, my lord. That is at page.
Lordship.
Order is at page 64.
15/12/2023, where is that?
16:4.
Ah, got it.
64. 64, page 64.
Page 65. Speaking order.
65. 65, your lordship, 15 December 2023.
Where is the reason? Where is the reason in your, in the impugn order?
Reason is that, my lord, the petitioner applied on 26/3/2024 along with various documents.
26?
26/3/2014. Lordship will see page 66. Two dates are there. This is the main issue.
I've looked into
The last second paragraph, whereas it is clear from the
28/3/2014. Petitioner applied.
26/3/14 applied.
Huh? Page 66.
Yes.
Coming to the application on
And my lord, the
many of the
various
doc-
documents were required, my lord, was finally
Let us see
submitted
the
on
scheme.
64/2000.
How it is.
Scheme, my lord, was discontinued by the central government.
That
in
I
March
understand, but then
2025.
also the central government said
My lord,
that the state can very well proceed.
from our own, my lord.
Yes, now kindly see, what is the requirement as per the guideline?
My lord. The guidelines.
The
are
release of
that
the first and the
page
procedure
number
for
30
submission of the
32.
application seeking financial assistance are required to submit the application to the designated authority state mission. Applicants must submit their at least 2 months before the date of start of the commercial production in prescribed form. Release. The first installment of the grant would be released after the firm had utilized 50% of the term loan, as well as 50% of the promotion and on production of the notarized security book. Deeply notarized certificate, bank certificate certifying. The second installment of the year would be released only after confirming the commencement of the. Mr. Gugoi, you are revenue?
No, here, my lord, for the industries department.
I'm
it's
otherwise.
Not for revenue.
Revenue and disaster? You are.
I don't.
Madam, just wait for some time. I'll take up the another matter. There is other. Hey, hey, continue. Item number 2. You see, there is a sanction being granted. This is a case where interest is continuing.
Pardon.
Interest is being continuingly have to be paid. Taking into account that this comes within the ambit of the Employees Compensation Act. So 1923, they have an award. No award have been challenged. The district administration have not made the payment. And this petition was filed in the year 2022. Their claim is of the year 2004. So therefore, they have placed the matter now, after this court have taken a serious note into that aspect, have placed the matter before you. Yes. Take it up 1 week. Whatever sanction is required, give it so that they are in a position to make the payment. Although you are not a party in the instant proceeding, but this is a direction. I'll pass an order to them. So that otherwise, you see, this court has no other option but to attach the bank account, the head of account of the district administration, because this is how it is to be done. Heard Ms. Chakravarti, the learned counsel appearing on behalf of the petitioner. Ms. Yu Das, the learned additional senior government advocate Assam, appears on behalf of the respondent number 1 and 2. Oh, 2. 2 is you are there. Yes, finance also. You take it up. Whatever sanction is required, you give the sanction, because you see, every time there is an interest accruing, and the interest is 12%. 12%, na, madam?
Yes,
Yes.
6%, madam. 6%.
Now is it 6?
6%.
No, then it was 6. Now statutorily it has increased. This amount has to be paid, and these people are entitled from the amount from 2014. Mr. B. Gugoi appears on behalf of the respondent number 2. Pursuant to the order passed by this court on 29/10/2025. Miss Udas, the learned additional senior government advocate, places before this court an instruction dated 10/11/2025, wherein a sanction proposal for payment under the head of account 2235-01-0933-032-01 SOPD-G have been placed before the Revenue and Disaster Management Department for necessary processing and release of the funds. In that regard, the District Commissioner Dhubri have sought for a period of 15 days for making payment in compliance with the order. It is also seen that the District Commissioner had also issued the sanction order on No, what are these two sanction orders?
Sanction order 9th of November we put it.
19th November is different.
Yes. It was in cancellation. We
This is different. This is only for 3 persons. But we are concerned with how many? There are 5 persons.
Five petitions.
Yeah, 5 petitioners, there are the 97,000 accepted.
Then why the next one is so and so?
It is in cancellation.
Election.
Huh? Of the letter dated sanction is hereby accorded as ex gratia to the injured person for release of so and so. So you are cancelling 3110. But again on 10/11 you are asking the same amount.
There must be something, madam.
Hmm?
19,87,000.
And this interest calculation is not up to date.
It has been banned.
No, it cannot be up to date because what he has done is, finally see earlier, the same amount was fixed
Yes.
as on 22/2/2023.
Hmm.
So it appears that the district commissioner is playing hide and seek. Yeah, we therefore take it up seriously. No, madam, you see, I have already recorded 19,87,504 on the basis of a letter written by the district commissioner on 22/2/2023. And if that be so, why is he sanctioning again after 2 years the same amount when the interest he knows is accruing at 6%? Doesn't seem to be bona fide. Ask him to get me the head of account. We seize it. We attach it till no payment has to be made. Get him the head of account. Otherwise, ask him to be present at 2 o'clock. To the video conferencing link, ask him to be present if he have not understood. We should catch hold of this type of people. He's trying to play hide and seek with this court. Very serious. So this is for what? This is a capital investment scheme, like a capital investment.
Okay, MOPE. Ministry of Food Processing.
Mr. Gogoi, this is a capital investment. Kindly
Kindly
come to page
It says,
32.
my lord, to scheme envisages, lordship will see page 32.
Yes,
Now,
so it is like a capital investment
Yes.
whereby
potential
for
assistance
plant
for
and machinery, they are giving for
the
northeastern
new
states
expansion.
for 50%.
Yeah.
50% of, and the maximum, subject to a maximum of 100 lakhs for northeastern, including Sikkim. Ineligible are these. Ineligible
So, lordship
list
will
of
see
plant and
number-
machineries
serial
are
number
given.
4, my lord, serial
Huh?
4 at page 32. Pattern of assistance.
So that is why
Yes.
we come on, here it is in Assam, so therefore it will be 50%. For the plant and machinery, there are eligible, ineligible components which are being mentioned.
Lordship.
Receipt of the application. State Mission Directorate of so may assess the load of application to be received by them and accordingly decide with the approval of the SLC. Modus operandi of receipt of the application directly or through the bank financial strength in case of the applicant does not propose to avail any term loan. Proposals are compulsorily required to be apprised by any nationalized bank. Public financial strength.
.33%, my lord, not 50%. 33.33%.
Number 2. Why you are saying 33.33?
Yes, my lord, clause 4, second paragraph.
No,
Better assistance.
You don't come under this. You come under next one, 50%. See,
50% not, my lord.
you are not
Notice
in
that-
Assam.
Yes, include, yes. 50%, sorry.
Then you are doing this matter for how long?
70.
Then 50%. So
Yes,
now,
yes,
Mr.
30%.
Gogoi, what is this receipt of application? Is it through the financial institution?
Yes, my lord. No, it says, my lord, the state mission director will receive it. So the application.
No, the
That
state
is
mission may assess the load of application to be received by them and accordingly decide with the approval of the SLEC modus operandi of receipt of the application directly or through bank.
Yes.
So it can be directly by the person or through
Or
bank.
to the bank. But in case of, if it is not a term loan,
Does not propose to avail any term loan,
Then it will
proposals
be
are
to the bank.
compulsorily required to be appraised by any nationalized bank.
so that's the condition.
So if he doesn't take the term loan,
Then,
then it is through this bank. Then it has to be bank.
yes.
SLEC may decide the financial institution which can appraise such debt. Procedure for submission, so he will submit 2 months before the commercial production. Isn't it?
Yes.
Applicants, so the last date is 2 months.
Now there is 2 months prior to production.
Now, this is a scheme of the central government.
Fine.
Now, the central government have said about the scheme for 2013. What is the period of the
My lord,
scheme?
the page 32, from 13 to 17.
Huh?
12 plan. From 2013 to 2007.
It is for
But in
2000, but
this way, it
what
was
is the
2000.
end period? Implementation schedule of the project would be about 12 months from the date of issue of the approval letter. State mission will hear. Now, this is the application form filed.
Just file on.
26/3/2016.
2014.
Then already started. Completion June 2014. Plant and machinery completion of six model January 2000. Site delivery June 2024. Commissioning of the unit September, trial run September, commercial October. So as per this, should not be before. There should be at least 2 months before the date of start of commercial production. So their date of commercial production they were envisaging in the month of October 2014 and they submitted in the month of March. So it is within time.
Yes.
Now, along with that, there are requirements of submission of a security bond, a certificate from the CLA. Isn't it?
Yes.
Now, they submitted these documents when?
my lord, that was submitted on 16/4/2015. This is very clear from
Oh,
the
that
page
means
6.
you are saying that this was not submitted within time.
Yes, along with the application, proper documents were not submitted, so that's why I could not, my lord, process that.
But why you have not given reasons in your order then? The order is without reasons.
Finally,
You
yes,
should have
wait
taken
a-
up this plea. You see, when there are various judgments of the Supreme Court which say that when you are applying for exemption, the exemption you have to apply, that is a very strict liability, you are to apply as per what is the mandate.
Yeah.
That is the judgment, I forgot, recent judgment, not 1 year back. Now, in the application, in the scheme itself, it has been categorically mentioned two things. One is you need a CA certificate and the other is a surety bond.
Yes.
Isn't it?
yes, ma'am.
In clause number 5.
Yes.
So, and it is also says that you are to submit the application within 2 months, prior to 2 months. If they have gone for commercial production in the month of October 2014, could they have done so by submitting these two without submission of an
No, that
incomplete?
They can always go, my lord, there
Huh?
is no bar, my lord, in the present case, my lord, there was only, my lord, modernization of the machineries, my lord.
Expansion in it.
Expansion and modernization, that's their part.
Expansion,
It was
yeah.
already there, it is an existing industry, it was already continuing production. What we will see, that's why, my lord, very beginning, page, I did 32 it says, my lord. Last line, the scheme objective, my lord, the scheme envisages to extend the financial assistance for establishment of new food processing unit as well as technological upgradation and expansion of existing units in the country.
So therefore, you see kindly page 35. Number 5. The existing operation is running smoothly.
Yes.
Turnover of the unit during 2012-13 was rupees so and so, and during 11-12 it was so and so.
Right.
Thus, there is an increase of 39% in comparison with so and so.
Then 12, my lord, serial
Ah.
number 12 in the same page.
In case of install capacity 5,000, prior expansion 70,000, 7 lakhs after expansion. So there is a expansion unit, how much is required?
It's up to them, my lord. Lord, you will see again 36, serial number 13.
Expansion is by 25%. What is the mandate of expansion?
That has not been defined.
That has not been defined.
It is never done in this manner.
No, probably, my lord, the entire scheme has not been placed. my lord.
This is the standard format form, my lord. This is the standard format form. So they have filled,
You have the scheme.
they've submitted all
That
documents.
Scheme is not with me, my lord. I got that bit yesterday, my lord. I've been
Yes, I
updated
have,
with this
sir.
yesterday. It will be a big volume, my lord.
But the problem arises here, Mr. Iya, that you see,
Now the entire scheme will.
how is it possible
Yes.
that the scheme is made in such a manner that if a person makes an investment or a new investment, he is entitled to an expansion without formulating how much is the percentage.
Not-
Normally, what happens is that there is an increase by 25%, which I could see in all the industrial policies normally. The central government policies were the NEIP, the NIEP, and all this thing. So they provide a particular thing.
It is there. Looking order somewhere I found it.
To hate it, to pray.
Actually, they have filed 4 affidavits, taking different stance on it. Last affidavit, they can understand we have not filed the documents. But the technical reports and GM forwarded after scrutinizing, inspection, inspecting and forwarded proposal. And it is a admitted fact they did not process the file. Till we come to the court.
No, your thing has not reached SLEC.
SLC because they have stated, so no meeting was held. They should have processed my file after when I have
No, in the
filed the
mean, no, the
application.
problem arises in view of the central government pulling out.
Up to 16, in the impugn order it is stated, up to 16, what are the files, my lord, under process? This should be after 16, they will.
The files which are under process means this is only a, where is the scheme?
Actually, it is gathered dust.
Well,
There is
page
no
70
communication from.
Document page 74, this is part of our affidavit that is part of the writ petition, 74, para 8. Here it says, my lord, in down below, my lord, the last fourth line. However, as the application of the petitioner could not be placed in this meeting, as the financial assistant thought was in the category of more than 25 lakh. That is 25 to 50 lakh.
About the application.
Huh?
It is
This
50
category-
plus.
In view of the state
They should have
assessment,
held a
that with
meeting.
regard to the paragraph number 8, it is stated that Niranjan Bikari Silcha was
They haven't
sanctioned and
meeting
was under the
meeting
category of aid of 25.
Normally.
With regard, it is stated that the state effort hereby meeting of the committee to sanction financial support they held many dates during so and so to so and so into keep of huge numbers of applications that can be however the application not
They have neglected, did not process the file, not a single letter, not a single communication.
is there any bar in having already availed some other schemes?
That part, my lord, that's why I said, well, probably the entire scheme is not here, only 3 pages there, my lord, is the writ petition.
Here they have given
To see that,
immediate
because
plan.
They have
is-
stated
No bar.
technically in the affidavit that, my lord, it is already aware.
राखेंगे इसमें, वो पूरे में दिया ना, तो फाइल पर। क्या करता है? अगर हम ऐसे नहीं। Bana, এখান তো প্রথম ইউনিট তৈরিও পাবো, সেকেন্ড ইউনিট তৈরিও পাবো, এক্সটেনশন তৈরিও পাবো। পারে।
And what do you say, Mr. Chakraborty? What is this, your stand? It is all problem arose because of you. No, you have pulled out the finance. The state had no problem otherwise. Have you filed your affidavit? Have you made the union a party? Why haven't you filed affidavit?
Up to 16 months, my lord. They have that pending project, they will provide the fund up to 16.
Huh?
They have stated later on, my lord, it is in the government, that they will provide the fund for the pending project. Those who have filed in time, my lord, up to 16 March
Where is that?
2000. In the import order itself, it is stated, my lord.
It says, my lord, committed liability.
Omitted liability, my lord.
67 of the writ petition, part of the.
Had clarified that no government of India funds would be available for implementation by the state from the financial year
67.
2015-16.
Yes,
and onwards in view of the delinking of financial year.
Where-
In the same letter, the Ministry of so and so had also mentioned that since the mission has been dealing for financial assistance of Iman,
Which
and
paragraph?
the government of Assam was requested to ensure funds for all the ongoing projects
Ongoing
approved
projects.
by the SLEC,
See, including the
including
committed
from the
liabilities.
state resources with a request to the state government to make decision regarding implementing the so and so or otherwise with effect from Iman onward. So this is a request.
Yes, madam.
But the thing is, can the central government make a request to the state government and you say that you do it? My scheme, I am not going to do unless
You
the
know, what
funds
they
are not
doing,
being
my
given to
lords,
them.
After 26th of March, what they are doing, man, it was December.
So you will see the third paragraph, whereas the process of the proposal under reference was not completed for late submission of required documentary of the petitioner. by
That
the
is not
applicant.
true. That is
And
not
no
absolutely
legal
false.
liability was created against the proposal under the.
Because the ZM functional manager, they have
Therefore,
processed the file.
proposal
They are the authority, scrutiny authority.
is before
Have
the
all
applicant.
documents are submitted. It is the second time they have asked.
As per the guideline of the NFP.
The functional manager and general manager, they are the authority who will process the file, inspect the industry and everything, the base work they are doing, they have duly forwarded the file, including all documents. So when we came to court, they are filing all these 4 affidavits, stating it difference. Because the file was gathered, dust, they ignore it.
Where can we get this OM number of 17th of August 2015?
Hello, that's it. At a file, government, second file, second file, it's over there. 17 is the issued by Penny and because India Union budget discontinued by the allegation of scheme. All these documents, it is filed before this court, my lord, by the earlier advocate. No from to the state. Any document will like this. This is the type copy. The option 17 August notification is there, office memorandum. One employee agate diya hai. Photo picture. Don't find it like you know this like this. Okay.
নহয় কাৰণ সেইখন বাকী কেইটা কি You get the point here, page 175. See the third query. Page 175 of this paper book, the entire paper. That is an affidavit filed by the affidavit in reply filed by the petitioner on 16 July 2020.
Means 29. Yeah. 116. Okay. কালকে হচ্ছে সেগুলো ফাইল করে রাখা হবে ডকুমেন্ট বিলাক সব অঞ্জনে ফাইল করা ক্ষেত্রে ফাইল করে ফাইল করতে যাতে হিয়ারিং হয় সেটা আবার করে
You have a copy of the affidavit filed by the petitioner on 16th of July 2024.
Yes, yes, yes.
There, if you see, they have enclosed another affidavit.
Yes, sir. File in
And
earlier-
then there is a letter issued by the Development Corporation, Annexure B.
73,
15-3.
53, yes, sir. Page
See the
116.
third point.
Whether the petitioner received funds from the government of India for the same unit and same machinery. Information here, the petitioner unit has availed the funds from government of India Ministry of Food Processing Industries for an amount of rupees 49.50 lakhs by scheme reference number which was dated 22 April 2012 for setting up complete unit in the fund. The matter was informed by the administrative proposal was under upgradation program of the with the stock of against which machinery the unit has already availed government of India grant and for which machinery they had applied under this scheme. This was the senior certificate mentioning details was prepared on 16/4/2015 only and presented subsequently for which a thorough scrutiny of document was verified for non-duplication. Four also, no, receiving of such part does not disqualify the industrial business for any benefit. The unit is eligible for available under technology upgradation and modernization for additional machinery for upgradation plus modernization. But also we'll have to see point number 2 also.
Yes, no, I understand. Now, you see, point number 2 says that she did not submit a complete application.
Right.
And it was very difficult to know. That is why point number 3 comes.
Yes.
Because they have already taken 49 lakhs. And out of that, it was very difficult to know without the certificate of the authority. Isn't it?
Right.
Now, in that backdrop, you come here to your affidavit at page 75. More particularly, paragraph 8. The answer of the affidavit filed by the filed in another
Earlier,
earlier.
মানে
Read paragraph. Does it make sense? Obvious then.
Page 75, we are saying that, my lord, since one it has been able, it cannot be granted, probably that will not come in.
No,
So
not
why-
only that. You said that the certificate was provided on 16/4/2015. That's your stand in the impugned order.
Yes.
The mention which have been mentioned, the document at page 175, which I've read it.
Got
More particularly, he said that the petitioner had earlier availed 49 lakh in respect for the purpose of setting up the industry in 2012.
Yes.
So it was very difficult to know what was the actual expansion in respect to what goods the expansion has happened.
Fine.
It was only on the basis of the CS certificate it could be known which are the documents.
Right.
Now this CS certificate was on 16/4. If it was on 16/4/2015,
Over.
why in the month of August, when you heard it, took up, you raised the issue of 49? Does it make sense?
But otherwise, my lord, it was issued on 16/4, it is very clear from page 100. We have annexed that certificate of the matter. Page 100. Part of the affidavit, my lord, additional affidavit that has been filed.
It is the additional document again resubmitted.
Page 100. Chartered account.
Yes.
Then looking at the next page, the date is 16/4/20.
Okay, now here, this certificate does not say, still doesn't say.
No, in the beginning it says, we hereby specify has made capital investment in the for expansion of Putani in the first line. Under for manufacturing of agricultural products. The case is product. So, make it. How it says, well, after expansion on 23/15, the tentative was well, October 14.
Huh?
In the last line of the
That is okay.
Page 44. Can we see page 44, my lord? CS certificate was given on 25th of March 24. Page 44. Huh? Hmm. No, I can't have a page, no, I just. CS certificate was given on 25th of March 24.
So therefore, this is the additional, this is the expansion.
Yeah, expansion has been made, but my lord, for that, my lord, the application was processed. Sometimes, my lord, in April. And my lord, additional documents are submitted when the scheme has been withdrawn by the council of March 2016. We have
But then also, you did not take up, this was, kindly see your affidavit which was paid. That is the affidavit why I am saying. This affidavit which is given at page 75, kindly look at it. What is the paragraph 8 that after what has been from 50 lakh, it is to be shared by the additional so and so. Then you see, it is stated there.
It is stated that after the appointed meeting, that is 19/8/2015,
No, it is stated that the meetings of the committee for sanction of financial assistance. Paragraph 8,
Yes,
page 74.
74. Yes. It is stated that the meeting of the committee to sanction financial assistance up to ₹25 lakh were held any day during 13 to 15. Due to the receipt of huge number of applications in the category. Doing so, the application of so was also sanctioned as the financial assistance shortfall was up to 25 lakh. Petitioner is
Then,
above
then,
that.
then further go to
However, the application of the petitioner could not be placed in those meetings as the financial assistance sought was in the category of more than 25 lakh. It is pertinent to mention here that the first meeting of the committee for sanctioning of financial assistance of 25 lakh to 50 lakh was held on 19th.
So you are still considering, in spite of that being gone. Now you see further clear.
Only wherein the application of the petitioner could not be placed as it came to the notice of the authority, the petitioner already availed two other grants under the Ministry of Food Processing Industries against the same unit, which was not allowed under the aforesaid NMFT scheme. It is stated that after the aforesaid meeting, it is going to no further meeting of the committee for sanction of financial assistance of the period.
So therefore I'm saying, read this with that letter of ASSI, where they are saying that there was a problem, why you needed the charter accountant certificate. Now the charter accountant gives a certificate to the effect that for the purpose of expansion, this is the amount which is being spent. And it further says in that particular term, category, very clearly another aspect, that look here, earlier there was a problem with this 49 lakh, which there is a reference.
Yes.
This only 49 lakhs he has received. So this particular 49 lakhs, there was a problem because for the year 2012, they have received.
Yes.
Subsequently, for the purpose of expansion without the certificate, it was not possible. So once they got the certificate, so the certificate is 16/4/2015. Now in the month of October, when you hold this meeting, you don't consider for whatever good reasons, when you have the certificate very much. Does it tell with
Yes,
this?
sir, there was some conflict is there because in August, my lord, we have held a meeting as per the affidavit.
So therefore, till August, you are still considering.
That will have to clarify, my lord.
It is apparent.
No, that's why, my lord, because this does not, my lord, tell you with the speaking order. Well, let me place the record. For the first time I put
Record?
yes, because it will be clear from the record. My lord. Why, my lord, again?
And he has no role. Anyway, you be there because of the fact that one thing good is your appearance can show.
One thing, my lord, that CS certificate was presented along with the application. That is of dated 25th of March 2014. It is there enclosed, page 44.
Madam, let
Later
us
on, my lord,
not travel to that so far a distance, taking into account
yes,
that as per the application, you were required to submit the surety bond as well as the CS certificate,
yes,
which
my- yes.
admittedly you did not submit. this
Submit, we have
16/4/2000.
submitted. That's why GM has forwarded, General Manager has forwarded.
You submitted on 16/4/2015.
That is the second, my lord. Earlier when, my lord, they were not getting scheme.
Okay, which is your certificate?
2014, 2014
There is one
file,
page
they were
44.
sitting tight, second time, my lord. These documents have second time.
That is not-
First
this
time,
one I will have to
they went
take.
closed, because GM is a responsible officer. Punjab National Bank, everything have submitted,
Down below.
Page 44. along with the application, you have to file these documents, otherwise how they will entertain the application. And
So
that,
this certificate was given.
yes,
And where is the surety bond?
and my lord, surety bond, that time actually surety bond is not necessary. When at this stage, my lord, when the.
Anyway, surety
sanction,
bond
yes.
was not
All
there.
documents, my lord, bank document, next, my lord, page 45, page 46,
Surety bond
finance
is at page
assistant,
97.
page 47, everything we have submitted. Hereafter only GM has forwarded with recommendation. GM functional manager has given a note. They are the authority to inspect all these things. Functional manager is the authority. Comments of the inquiry officer, page 42. Certificate that I have examined each and every particulars furnished by the claimant, Messrs. Vivavekars and the unit Vivavekar.
Oh, this is the inquiry form, na?
Yes, my lord, page 42.
It-
And documents, relevant documents, they are not fools. Relevant documents furnished with the claim, found them to be correct and beyond all reasonable doubt. I have also personally visited the unit on 27 so-and-so and the prices mentioned in the application for land, building, plant and machinery component items with original documents and found them to be correct. They have the recommended amount of so-and-so, he has given a statement. Next letter is by GM, my lord. page 43. These are fourth affidavit they have filed stating all these false allegations. With reference to the caption subject, I have the honor to forward herewith the application for availing financial assistance under so-and-so, duly filed and signed together with required enclosures as received from so-and-so, so-and-so, and food documents of so-and-so, Melvin so-and-so. This is an existing unit and now envisages an expansion cum modernization program. The unit has submitted all the required documents as per guideline of NMFPF. The project is under implementation with the financial support of Punjab National Bank, Silchar. The claim was duly been verified by the functional manager, Sri so-and-so, so-and-so, and inquiry report in the prescribed format is also enclosed herewith for favorable kind consideration. The GMS forwarded, he is a district head. So I cannot say or one will not suspect his documents were filed. It's not a lapse of document. The 2 years.
Surety bond, my lord, not submitted. It is required
Surety
under
bond not required.
Clause 8.1, Roman 1,
No, my lord.
page 33.
As per my knowledge, my lord, surety bond required after sanctioned by SLC. I myself have several units. Just availing such. I don't think the site of price.
So here, this particular document
Sanction
issued by the general manager, district administration, industries and commerce, page 43.
Yes.
Categorically says that all the unit has all required documents as per the guidelines of so and so. Now, how can you now say that these documents were, because you have, now if we again go back to page 33, you see receipt of the application, it will be done by so and so, and they will have the module by which it will be done. So you have fixed, unless you say that the general manager, district industry centers have no business out there. You have not said that. So therefore, here it says that it is apparent. So if that be so, then why the petitioner, you cannot
Another question, my
deprive the
lord.
petitioner of the dues?
Another question, my lord. In the first affidavit, they should have made this allegation. But this allegation is made not filed in fourth affidavit.
Huh?
They have filed affidavit 4 times, my lord. One first affidavit, additional. In the fourth affidavit, they had made allegation because when the court was, my lord, scolding them or my lord, sometimes, my lord, it was found. And you see, on court direction, they have filed fourth affidavit where the allegation is made, you have not filed this, you have not filed this, that. But in the initial stage, my lord, they have not made this allegation. Why on the first affidavit, they should have, whatever they have got, my lord, our loopholes, they should have filed all this pointing out, my lord, in the first affidavit. One letter only on order, my lord, I want to place by, in the earlier case,
No,
my lord.
no, madam, you show me one more thing. Where is the document by which the central government says that we are not going to pay any further?
I have no issue, a copy of that, man. Now,
Mr.
stop again started.
That 2017 document, Lordship, the petitioner has filed in the document.
Huh?
Lordship will see the last page.
Huh?
That 17 August 2000.
When I filed, see me,
All
the
those document, my
I
type
can't
copy
read
was furnished. One type copy was furnished.
Ah.
17 August 2015. The last page.
15,
Yes.
15 August, maybe. More from photo, no? You want to come like
Here,
that?
my last page. Roman 6, Central Sector Schemes, number B. The AM is the administrative approval and FS is the financial settlement. For all those schemes which are in the state budget, 1560, but not in the union budget, will not be given by the administrative department. Any AA and FS already
Type
given
copy from my- there are
will be treated as cancelled. And formal orders to this effect will be issued by the executive department.
AA and FS means financial sanction of all the schemes which were included in the union budget and the state budget will be given as per the DPF. What is that?
The
DFP. And the connected OM of PNB Finance Department subject to budgetary ceiling in the state budget and receipt of the funds in the state exchequer from the government of India. And all those schemes we are in the state budget shall not in, but not in the union will not be given effect by the administrative department. Any so will be treated as cancel and formal work orders with effect will be issued by the administrative department. All such schemes which are in the union budget of 15 but not in the state budget will be given as per the existing DFP. What is DFP?
Another letter is there, my lord,
Huh?
by Managing Director of AIDC to the Under Secretary, Ministry of Food Processing, Government of India.
Page?
Page 64. Here it is mentioned, my lord. Third paragraph. Submit here in the detail of so-and-so. In this regard is to mention that the scheme was dealing for financial assistance from central government as per DO letter. MP so-and-so budget 12 to 17. The payment from the Secretary, Ministry of Affairs, so-and-so, and SLC, approved by SLC, including the committed liabilities from state resources, so-and-so. Third paragraph, my lord. Accordingly, Industries and Commerce Department, Government of Assam, had made budgetary provision under the scheme for an amount of rupees 1 crore of for 16-17 and so lakh in the year and so clear to total committed liabilities amounting to so 1,000.
Mr. Who appears for the union? None. Wait, wait. If you don't file an affidavit later on, don't say in this matter.
15 had
We take it as if because you see,
decided
it
that
appears it is your scheme. After all, are you a standing counsel? Don't appear, now appears for union. Union is not bothered. So we have the secretary present in the court. It's the way out. So does he think that the matter, when the court is taking up the matter, to go away without informing the court? Is this what is being taught by to you? You are his junior. Huh?
to request to kindly make necessary arrangement for compliance of the High Court order. He is managing director of health.
So, boy, you have to look into one thing. It appears that you have to pay, but you have to look into it. I think the central government, see the central government, they cannot put upon the burden upon the state that state you pay it from your resources unless the central government does not pay. So therefore, how can I pass a direction on the central government? Anyways, they have not filed it. Pass the direction again. So they are to honor. And as he filed the application between that time, you are just an implementing agency. You are like a nodal agency, which normally in all other industries, all other schemes, it is that
90% is given by central government.
90%, 10%.
10% by state.
10%, 90% central.
Huh?
Central share is 90%.
here you are, it is you who is paid with
No,
the
no,
central
not
government.
paying, you got the financial assistance that we'll have to get from the central government is 90%. 10% will be of the state. Entire.
Anyways, so out of 50 lakhs,
Yes.
his claim is around 33 lakhs or something. So
57.
claim may be, the fact remains that it is a scheme of the central government.
Exactly.
So the central government, if they remove it from the budget on account of that finance commission is not there, but the Niti Aayog has come in. But what promises which we have made and on the basis of which expansions were made at that point of time and duly certified the year when the union has to, they may give up whatever may be, later on it may happen, but in the meantime, which has already happened, they are to take,
They've shifted their position.
they cannot shift the position there, so they are to pay. So therefore, there has to be appropriate directions to the union as well as you for making.
And more so, when the scheme was from 13 to 7. In the midway, it was.
So therefore, they no, and they have applied within that time. Unless you say that the certificate which has been given by that chartered accountant on 26, or the general manager has given, because you have not stated that.
Nothing is.
They say that everything is there. So it appears that later on you are taking up a fee that they have given. They must have given as a Additionally, they had to give another certificate of that. But the inquiry report also showed that there is an additional amount of 1.192 lakhs which have been incurred at the expansion. Although the certificate of the chartered accountant says something around 100 lakhs. But be it as it may, so this certificate is there. You may say the certificate is wrong, right? That is another aspect of the matter. But you are bound. So the central government comes out here and says that look here, we have given up. They cannot. They have to make the payment of that
Their part
90% of whatever it is.
Yes.
So they have, you did not file affidavit. Let them and with the record that Mr. P. Chakraborty says that whatever has been this court direct, they will do the deed.
Yes.
So we pass in that order.
Yes.
That is-
And recently, my lord, in two old my lord cases, recently in the month of September, they have paid to my client, my lord, 2 unit, 2 together. So order is passed, my lord, we will let.
Get the records, my lord, at least to see, my lord, whether before that, as annexed in the repetition at page 44, whether the document was there or.
You see whether the general manager, that document,
that-
and
General
whether
manager.
that general manager's document is authentic. They're not concerned with the certificate later, because the general manager is your agent.
Right.
And he being your agent, he is also the agent of the central government because of the fact that you are the implementer.
Implementing.
Yes.
So therefore, he has to, if the general manager has said that all the documents have been given, later on you can't take them. Apart from that, the certificate may be, the charter accountant certificate which may have been given out there, the later on, has to be taken as a continuation of the earlier one. So it is not that they have not, unless you show that the earlier certificate has been rejected. But your stand out here, you said there was no certificate given. And this is also being mentioned in a subsequent letter by the managing director of ASSIPC,
Yeah,
where he also mentioned that the entire is not good or good comply. But be that as it may, if it is the amount of 49 lakhs, it doesn't tell. Because the 49 lakhs on one hand you are saying, but you wanted the certificate and the certificate was given on 16/4. But in the month when you are taking up in the month of August, you just brush aside the standard of the petitioner on the page.
That panel, my lord,
That
is
cannot happen.
my lord, contrary to our.
This is very damaging on your part.
Yes.
And more particularly at that point of time, you were also looking into other. You didn't say that no, okay, yes. You see, the scheme may be 10 lakh, 5 lakh, 4 lakh, 5 lakh, or 50 lakh. Maybe that it may be different. But the fact remains that you were still pursuing in respect to those claims. You are saying that from 2013 to 15, there have been various meetings below 25. But in respect to 25 and above, they were only in the month of August.
Right.
But the fact remains that you are still considering.
That's
How do you
Post- post-
how do you take the note of your stand when you say that they have given up, so we are not loyal? But on the other hand, you are still considering beyond the budget. Budget comes only from 1/4 2015. So prior to that, after that also you have been considering, and you have paid somebody 10 lakhs and all. So therefore, the question is that it appears that the petitioner is entitled to the relief. And I am not going to further disturb your people out there to reject his representation any further. I think that this needs a quietness. But anyways, I'll give you a time for the production.
The record, GM records has come to this office, my lord. And records are produced, my lord, whether it is returned back again.
Madam, I have understood your case. I can very well dictate it.
Yes,
But he wants to produce the records. So let him produce the records
it was placed in
That
the,
is-
before the earlier bench.
so that I can pass them on. And I don't make
See,
it
make it
so I-
further, my lord. Since your lordship has heard for so many times, again, my lord.
Not so many times. This is the
No,
first.
no, my lord. First time,
Madam,
but
kindly
my
don't
lord,
say.
no, my lord.
Kindly don't
no.
say.
Keep
You
it-
see,
keep
Mr.
it
Rajesh
further
Majumdar
so
was
that he can
taking.
place the record and pass the order.
No, madam, kindly don't say. Earlier, 13/5/2025,
The judgment was reserved
judgment reserved concluded. So earlier,
for
Mr.
a few months.
Justice Jamil was hearing this matter. When it came before me on 1/8/2025.
today only you have had.
Appearing on behalf.
So many
of
times,
Mr.
sir, so many times.
Justice N. Sophia, the learned counsel is suffering from me.
Today.
And then the matter came up before Rajesh.
No, your lordship did not have.
Your
Your lordship did not have.
Therefore,
Earlier the
this
others
is for the
doesn't-
first time I'm thinking.
Other benches were hiring. And
Huh?
Jamil also, my lord, minimum 10 days he have heard.
That is.
Justice Jamil also, my lord.
But for
But
me,
judgment
I
was
think
reserved.
we need to complete it. as
Yes, my
soon as
lord.
possible.
My humble request is,
By-
my lord,
By
since
the
your
end of this
lordship,
month,
since your lordship has gone into the merit of the
Madam,
case.
I think by the end of the month, he will get the judge
Yes,
in the open.
Yes,
Anyways, none appears for the. Okay, you produce the records.
Yes, yes.
And have a look, because you see, this is the point.
Yeah, that is the part, madam. And
Otherwise, what you have done, that order, whether that order is also, there's no reason. So and so, and therefore we reject it. But anyway, to further not permitting these people to look into it, we pass the order.
to submit two things, my lord. Earlier also I submitted, but it is not in the file. My lord, I have submitted a written argument. Mr. Anjan Kolita also submitted, standing counsel, and a written argument and a list of, my lord, cases, referred cases. So, again, written argument, there.
Yes,
But in the file, it is
written
missing, my lord.
arguments. There is a written argument, wait.
It is there, my lord, written argument,
No, there is some Supreme Court judgment. There is a lot of judgment.
on additional আছে, এখন additional আছে,
Promissory estoppel, Motilal Patampal.
additional বলুন।
But then written argument is there. Viva, here written argument given by Malavika Sharma. Who is Malavika Sharma?
It is there, my lord, written argument is.
Who is
there.
Malavika Sharma?
Junior maybe,
Your junior.
girls are there.
Let us-
It is there, my lord, written argument copy is there.
Ah,
Okay, my lord. So, my lord, the list of bonds was missing, my lord.
Huh?
These, my lord, referred cases, bonds was missing.
that is also there. But I don't require so much.
Yes, my lord. That's it.
So much.
I have to try my best
So much
to,
of judgment.
I have
is
to
for
try my best,
this-
my lord, that's it.
Anyway,
It is fine, my lord.
our Ms. N. Sekia, the council appearing on behalf of the petitioner, Mr. P. Gogoi, the learned additional advocate general, appearing on behalf of the state as well as the industries and commerce department of the government. Mr. So-and-so, who appears on behalf of NETP, and Mr. B. Chakraborty, who appears on behalf of the central government. The matter have been heard at length. This court made a specific query upon Mr. B. Chakraborty, the learned counsel appearing on behalf of the central government, as to why no affidavit has been filed on behalf of the central government. It has been submitted that the union, that the union, that the respondent number one would only make payment upon the formalities being completed by the state government. And as the state government is not satisfied with the application, the respondent number one has no liability to make payment. This court also heard Mr. P. Gogoi, the learned additional advocate general. And after hearing, and after hearing the learned counsel, upon hearing, this court had also posed a question in respect to the Annexure 5 of Annexure 4 and Annexure 3, 4, 5, and 6 of the writ petition. And more particularly, when the general manager, who is the nodal authority, accepting the applications, have duly certified that the petitioner had submitted all the required documents as per the guidelines in the NMPF. Mr. B. Gogoi, the learned counsel, submits that he would look into the records and if necessary, and also produce the same on the next date. List this matter on 20/11/2025 at 10:30 AM to final records. The records also be produced.
Comrade.
Take on board.
I need to pay the tax by control of the. After the control, he has sanctioned the amount. Then he has sent on 1st of November, that is the admit problem. Then the disaster management department found that since 2% petitioner expired, so cannot be, and again, it is not a 60 days of ex gratia amount, interest bill has to be calculated. That's why, again, they have sent for 3 sanction order. So he has issued, two sanction order. Case of 2 expired, petitioner, 1 sanction order, and in case of 3 injured, another sanction order. And that on, it is on 9th, and 10th he has sent. And regarding calculation of interest, yes, it is up to 23, 2023. So it will be calculated up to date and it will be paid, till after 7 days, it will be calculated up to till date of payment.
So these sanction orders are only up to, the interest is only up to 22.
Correct. Yes. After that, they will, the order passed, it has been calculated, and they will calculate till the payment, maybe please to pass order.
We fix it on 26th of November.
Yeah.
And thereby give us the, you want the payment.
My,
You, madam, you provide the, have you provided your bank detail?
Not it.
Can you get the bank detail by second?
May not be possible, my lord. By next day, I'll also give the bank.
With,
before
this
that,
matter has to finish by 2000, by 26. You have to get your money.
My lord, my lord.
We provide the bank details by tomorrow to us.
yes, yeah, I'll forward this.
Pursuant to the order passed by this court on 29/10/2025, it is seen that the District Commissioner Dhubri have provided instructions to Ms. Yudas, the learned additional senior government advocate, that active steps have been taken for the disbursal of the amount of rupees 19,87,504 to which the petitioners herein are entitled to. In that regard, the communication, the sanction order dated 9/11/2025, both dated 9/11/2025 of rupees 16,16,353 and rupees 3,71,151 have been respectively have also been produced. It has also been informed that the District Commissioner Dhubri have also intimated the Additional Chief Secretary to the Government of Assam Revenue and Disaster Management Department for providing the necessary funds so that the amount would be paid to the petitioner at the earliest. So although the Revenue and Disaster Management Department is not a party to the instant proceeding, taking into account that this is an award passed by the Commissioner Workmen Compensation against the District Commissioner Dhupri. But as there are requests being made by the District Commissioner Dhupri to the Additional Chief Secretary to the Government of Assam Revenue and Disaster Management Department for the purpose of appropriate sanction, this court have requested Mr. A. Bhattacharjee, the Learned Standing Counsel of the Revenue Disaster Management Department, to take up the matter with the Additional Chief Secretary to the Government of Assam Revenue and Disaster Management Department, so that the appropriate sanctions are being provided to the District Commissioner for due payment. So this court also takes note of that the total amount of rupees 19,87,504 is interest calculated till the month of February 2023. However, it is not apparent from the record, from the sanction order, that the District Commissioner Dhupri have duly taken note of that the interest has to be paid till the date of payment. Accordingly, Ms. Yudas, the Learned Additional Senior Government Advocate, upon instructions, submit that the petitioner would be paid the interest as directed in the awards, being WC case number 39/2003, 40/2003, 41/2003, 42/2003, and 43/2003, up to the date of payment. And the said amount would be paid within a period of 7 days from today. Taking into account the above, this court directs the instant writ petition to be listed on 26th of November 2025, 27th of November 2025 for an update. Ms. P. Chakraborty, the Learned Counsel, appearing on behalf of the petitioner, shall provide the bank details of the petitioner to Ms. Yudas, the Learned Additional Senior Government Advocate, by 13th of November 2025, so that the said details are forwarded to the District Commissioner Dhupri for due payment. Please take out. The instructions so placed before this court are kept of record and on the letter. But
Can it be taken up at through
why?
my miscase?
Let us see whether it has been demolished properly.
Ground floor is transferred, 4 units were given. Except one, but the remaining 3 have been done.
Why there one is not demolished?
One is,
No,
somebody has-
my floor is third floor.
Well, in fact, Malat, in respect of ground floor, the occupant, I approached, but the particular person, the Bihari people, they went to Bihar on Chhath Puja. They will come back by, Malat, today the voting is there, thereafter they will come. They requested me. I intimated the court's direction and order. They intimated that till they come back, they will vacate the premises, then it can be breakdown.
Did you, are these people your tenants?
Malik. Malik. I approached them in view of this court earlier order. I want to break that down that third floor.
But, Mr. Naik, don't you demolish at the cost of the petitioner?
Yeah.
Why you not doing it?
But if we are in the process of doing.
Okay. Do it.
My contention
Okay,
is,
ma'am.
Malad,
Absolutely nothing.
no, Malad, sometime.
No,
that we can see,
sometime.
we can-
You, no, you have got 10 years. And you are a tenant. You have no business out there.
No,
It is an absolute illegal construction.
no,
I
so
need
far,
a next.
so far, merit of the construction, Malad, we
Whether-
do not have anything to say.
You
Only,
cannot.
only Malad, some reasonable time.
No,
so that
you knew it very well.
we did not, Malad.
You
The
don't come up with
petitioner-
this. Let the division bench help you out. It has to be demolished. Nothing there.
So demolition is,
Division
Malad,
bench may help you out. I am not going to do that. You are his tenant. Your right flows from him.
yes, ma'am.
Eh?
Only, Malad, sometimes so that we can. get
24
the-
hours?
Malad, little more,
24 hours.
Malad, little more, Malad. And
Vacate by 24 hours.
the applicant number 4,
Should we also inform the youth? Don't you take the help of the police also?
Yeah.
Yeah. Should we also bring the police into the play and throw these people out? Huh? Police throw them?
only
They have no
for
business.
shifting of materials, Malad, because
What?
shifting of materials and the applicant number 4 is in hospital.
Who?
Applicant number 4, there are 4.
Oh, very good. He's very there in the hospital. He doesn't need the shelter.
Only
Very good. Throw them out. And demolish. This is absolutely. You don't have a right. Tomorrow he may say, oh, another person will come. Oh, I am actually the subtenant of him.
No. That,
He has no business in giving you you claim your right to him. You
Yes,
don't have any independent right.
definitely.
So therefore, his possession out there is absolutely illegal.
That is why, Malad, we
So
have not-
therefore, whatever he has done, you take money from him. You want the compensation from him, ask for compensation.
no compensation, Malad, but only the shifting time, night.
24 hours.
24 hours is too short.
24 hours is a good time. And demolish that ground floor also. Ground floor also. And if necessary, break those pillars also.
At
Yeah,
least, Malad,
absolutely. This is a matter going on for such a long time, 2024. And you have, Mr. Sharma, how many years you have been fighting for the demolishing of this?
13 years, Lord.
13 years.
It was
My
filed in 2013. And one thing is, if I may submit,
Yeah.
he is telling Mr. UK Goswami that this Bihari will come after Chhat Puja. He has come 3 days late, and yesterday I seen him in this old building signing the affidavit.
Is it?
Yes.
Signing affidavit?
Yes. That's why he will
No,
come
no,
like
they
that.
define the third
I
floor
think-
people most probably approached by Mr. Sharma. I have the instruction in the ground floor, the person, he will come back, he requested me so that he can bring out his belongings from there. Then I can break it down, but the ground floor regarding.
He had
No,
come
nothing.
4 days or 5 days back, your lord. The
No,
person
no,
on
no.
ground
This
floor-
cannot happen like this. It has to be demolished. And
at least 1 month time, Malad, so that we get.
boom.
for
you.
fast track.
1 month, 30 hours can be given at best. You are not going to demolish within 30 hours? Huh? No, get a bulldozer, demolish it on top. Remove that roof. There is a, what you call, they have put some tin. Remove that. The tin, remove the tin. The concrete is gone.
That is 4th floor.
Huh?
That is 4th floor.
So otherwise, in the 3rd floor also there is a tin. Huh? So half they have made tin and then they have constructed over half
30%.
they have made the concrete. Remove the tin. Let them stay in the scorching sun.
And your lordship, I personally told all the tenants when the first order was passed on 19 August, the demolition was done. That please vacate it. But then the staff of this private correspondent, he used to tell the tenant that you need not vacate it. We will get it regularized or like that. It has been happening. They are getting the wrong instruction, I don't know, but we have given talk to everyone, and one person that he is saying that he is in the hospital. He has given me a deed, only a sale deed, not a agreement of sale. He's telling, not a sale.
Who? That person, malab, that person,
is telling that he
that
is in
person,
the
that
hospital.
the hospital, applicant number 4, he actually purchased his portion.
Not purchase your lordship.
I do not know, malab. He told me that he has purchased that portion. That part of third floor. That presently he is occupying.
Mr. Sharma, you act on telling.
No, malab, because he is in hospital, malab.
No, I was submitting before this court that you act on, somebody
No,
tells
he's-
you something and you file your petition.
He is malab in hospital, malab.
Huh?
He is in hospital.
So,
That is why I could not.
very good, na? He has a shelter. These other three doesn't have. Mr. Nayak, can't we impose some cost upon this person concerned every day? Something around 15,000 per day of not removing? Isn't there any provision? So that they have to, and that will be given to. I'm not passing any stay order. You go ahead with your demolition, wherever you feel. You have to do it between dawn and dusk. So you do it. Go ahead, demolish whatever you feel like. And throw whatever, even they have TVs, throw them. In the meantime, if they remove the TV, it is good. Otherwise, throw them. One line. You need another 2-3 lines I've given you. But nothing more than that. This is to be demolished. Hey, I have production listed.
Well, in fact, Malad, I requested the third floor.
Mr. Goswami, nothing.
They
Mr. Goswami, don't come up with all these silly excuses. Whatever you are doing is not at all bona fide. I also understand. He also understands. Everybody understands. It is only that I am not actually getting how to make it so because of the step. GMC not breaking it.
1/1/2025 order passed by your lordship. Vacated the interim order. I approached the third floor occupant. I intimated them that in view of this, I'm going to break down. But they then definitely they approached today before your lordships. They requested in
Didn't
view
I
of
give
the
the
medical
permission
ground
today?
and other things.
Lordship.
Didn't I give the permission? Today?
Yes, madam.
Permission দিছিল কিবা পেকিঙন আনক পেকিঙনৰ ৰিজেক্ট কৰিলো আনিব দুটা বস্তু আনাইলো
One is for impleading,
At-
another is for interim protection.
Yes, I'll implead and then I will dismiss the other one so that you can very well be petitioner. Don't worry. And you demolish. I'm giving you only 4 days for demolishing the entire thing. Otherwise you take. And then we again have it on. But let me pass on. And how much cost? Take it from me. Eh? Yes, it will be recovered from him. And Mr. UK Goswami will give us surety bond, indemnity, that on behalf of the petitioner, he will be the person who will. Yes,
I am also hearing only one request, man, that since this is the last chance to be made, because already demolition has been done down floor as well as the fourth floor. Only third floor remains because there was the protective order ultimately not taken. Now we are commenting already the tenants because immediately they are unable to find bracket. But 1 week time, I think at this week or 10 days.
no, therefore I'm only therefore giving, for whom are you appearing now?
Under that 4 and 5, one petty.
You are appearing for the tenant.
No, that's for number 5 and petitioner in that's for number 4.
So you are appearing for the petitioner. So you have the intention of demolishing.
Yes, of course, they have to, actual court's order is there.
So
and-
therefore I'm saying, I'll give you 4 days to
But they
demolish.
have family and.
Nah, forget about family, they also know whatever you.
How much they have waited, at least 1 week time. 1 week I will sufficient, I
No,
think.
I'll
And
give you,
definitely-
therefore I'm giving you 4 days to demolish the entire
I have
thing.
only one
And
request,
thereupon you take,
one request only, sir, only for, I'm not asking for
no.
1 week's time.
You have no problem. You want,
Because-
well, didn't he say that he wanted to demolish and informed him?
They were searching, they were.
So therefore, you are, if you are appearing for, and both of you are appearing for him, so you want to demolish.
Have to have a-
So
Well,
therefore,
no,
why you are asking for him?
for him, they are also
Mister-
affected by, but they are.
Mi-
to search for-
Mr. Counsel, the question is,
Although we have. to-
don't try
to be
to,
out-
don't try to be very clever. We'll
there
take
is
it
no
up at,
question of
we'll
becoming-
take it up at 2, the other matter and demolish, dismiss his petition.
Sticking around.
Some yeah will help you, the division bench may help you, but
No, no,
this
no,
court is
no
going to,
question.
till I have this matter, I think
But
by
it's our time, my
December 1st, you shall have a proper trimmed ground floor.
But they are-
And and then you can also dry your wet clothes up there on the second floor.
They want to use the third floor actually, that is the reason they have come. They have, although they don't have no right, lots of earlier.
No, right, I
Last
do
week.
not have.
They don't have a right in respect to that. I'm not saying that they have a right on the ground floor.
Why they
The
have,
fact remains that there is an order of the gym.
there, MT plus your court order is.
Court
I
order is-
I have to have come back. I'll
Therefore
delete
not,
that because of that.
we'll see it too. The other matter,
Lodge,
his
at two,
application,
Lord.
let me reject it formally.
lodge.
Hearing item
Not
C.
sick, illness, some personal
At 2,
sick.
wait. Yes, Northeastern
Matlab-
Engineering and Associates by the Union of India.
Net zero.
What is this?
Matter relates to the non-payment contractors bill.
What are you challenging here?
My lord, in this case, my lord, the respondent number 2 has awarded contract to the, yes, awarded contract to the 2 and 5 for my lord setting up gas cracker project at Lepet Kota, Dibrugarh, my lord.
Huh?
For setting up gas cracker project, respondent 2 has
project?
been awarded a
So
contract.
what is the order you are challenging?
My lord, so far, my case is related to my lord, non-payment of contractors bill. I have been awarded to carry out some part of my lord,
1,81,00,000 directly to the petitioner by the respondent, direct record to give a detailed report of the pending bills. This matter has been filed in the year 2014.
14.
Until now, you have not got the money.
My lord. Thus, so far, my lord, that part is confirmed on last order, my lord, which is at page, my lord.
Did this matter come up before this court earlier?
No, no, my lord.
Huh?
No, my lord. Yesterday, day before yesterday, it was listed but not listed.
Oh, as illa could have it, the matter came up before this court. Tell me.
Now, my lord, so far the total bill amount is concerned, my lord.
Huh?
Some, my lord, discussion was
No,
taken.
you want money. Why they are not paying it?
My lord, because my lord, the contention of the respondent number 2 and 5 is such. There is no privacy of contact in between the petitioner and the respondent number 2 and 5. The contact lies in between my lord, the petitioner and the respondent number 4, my lord. That is why the respondent number 2 and 5 is not releasing the amount to the petitioner. Whereas my lord, the entire contact was have been carried out by the petitioner through my lord, respondent number 5. The bill has been submitted to the my lord, respondent number
But
2.
Mr. Sharma, I remember
My lord.
taking up a similar matter someday. Whether this is a matter or not, because isn't this the owner, some ownership firm?
No, no, my lord.
What is that? You gave a subcontract to him. I'll tell you, without seeing the file, you must have given a subcontract to him. And of that, some amount is to be paid to him. Now, you have been declared bankrupt or something to that effect, and some NCLT matters must have gone out there. And therefore, he wants that the money which is there to be paid, which you are going to pay to him, should be paid to him. Isn't it the case? Yes, I've taken some matter to that effect. But that was some Onachal person. Onachal man. But this is happening everywhere.
Now, my lord, my claim raised up not only against my lord 1 crore 81 lakh, my lord. It has been settled to
No,
9
no,
lakh.
but Mr. Salman,
Right.
you want that amount.
90 lakh, now 90 lakh.
But the fact remains, because in that matter also, I took it up, but then something happened, I couldn't take it up. What you want is this twofold. You want recovery of that amount, and in the meantime, attachment before judgment. That's your case.
Presently, my lord, so for the other LEDs concerned.
No. The fact
Yes.
remains that you want the amount from him,
Right.
but he is going to give that amount to her.
Right.
So therefore, you want that this amount should be paid by him to you, which this court cannot give, taking into account there is no privity of contract.
That's
Unless and until, which normally happens in NHIDCL, if I am wrong, not wrong. There is a provision by which a subcontractor can be given, whereby this particular person, the NHIDCL approves such subcontract, thereby there is a privity of contract between the NHIDCL with the subcontractor.
Right.
But this is not the case herein. So therefore, you have to go before the civil court. Why should this court look
Yes,
into all
yes.
these things?
my lord. That's true, my lord. One more. So for the my lord, the amount is concerned. The lordship may take look at
Amount admitted,
admitted. My lord.
fantastic. But the fact is, this is a dispute between you and her.
So for that part is concerned, if you lordship take look
And
the
if we start indulging into all these things, then it will have far reaching consequences.
only one letter may kindly be put. That will my lord.
No,
Only one letter. my lord.
no.
There has
Those
been
letters,
submitted-
nothing is for all these things for division bench looks into this. But my case is very simple. Because if you are asking this, tomorrow just for example,
Yes.
let us take an example. You have a dispute with somebody, a private contractor, any contract dispute, but you know that amount that government is to pay to him. So therefore you file a writ. This is what is happened. Then I give you the time out here. The pendency of the writ petition during this period shall be taken out while moving that court. That's over. Simple. But this matter I have heard somewhere. I can't be so much dead without seeing the file I can see.
my lord. Meanwhile, during the pendency, one point my lord lordship may take. By order dated my lord 29/2024, the Honorable Court has directed to take measurement and subsequently submit the report that was submitted on 28/10/2024, my lord. That is on the record, my lord. It was submitted by the respondent of 2 and 5, with whom, my lord, I have no direct contact. My lord. My lord, so far my work is concerned, they have not denied that we have not carried out
No, this
any
all
amount.
there, it's okay. But for your claim, what is your claim?
Now, my lord,
No, Mr. Sharma, your claim is very simple. That is why the matter has been dragging from last 11 years.
Yes, sir.
Only for this reason. Because this court is trying to function like a civil court. We can't function like a civil court.
That's
It's absolutely a pure contractual dispute between you and him. And this is the amount which is there for which you need an attachment. 38,
already what happened,
order
my lord,
38.
only my lord 90 lakhs has been my lord paid.
After a long time, they will back.
It will take more. Already, my lord, for 2014, my lord, we have.
So you have all these admissions, then if you can very well file a summary suit, go for under order 38. 37, summary. last. Heard Mr. M. K. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. Miss. Who appears for Union of India? None appears on behalf of the Union of India on call. You appear for 2, 3, and 4? Huh?
2 and 5. Respondent
2 and 3.
2 and 5.
2 and
5.
2 and 5. And Ms. P. Chakraborty appears for respondent number 3 and 4? 3 and 4. Only 4. Who appears for Brahmaputra Kekar?
For him.
P. P, I think normally should be appearing for, yeah. So, Lekhok. None appears for the respondent number 1 as well as the respondent number 3 on call. Mr. So-and-so appears on behalf of the respondent number 2 and 5. And Ms. P. Chakraborty appears for the respondent number 4. The instant repetition has been filed by the petitioner, being agreed. They're seeking a direction upon the respondent number 2 to release the bills amounting to rupees 1 crore 81 lakh directly to the petitioner. And further direct the respondent number 3 to give a detailed report of the pending bills to the respondent number 2. The material on record reveals that the respondent number 2 had allotted a contract in favor of
Respondent number 4, my lord.
the materials on record show that the respondent number 2 was allotted a work by the respondent number 3. For carrying out certain engineering projects. The respondent number 2 actually was not the year was not allotted. It was asked, requesting the proper word would be request. The materials on record show that the respondent number 2 was requested by the respondent number 3 to carry out certain project works. The respondent number 2 thereupon floated a tender for completion of the gas cracker project at Lapetaka. And the work was allotted and pursuant to the said tender process, the work was awarded to the respondent to, what is this full name? Don't know the full name also.
Brahmaputra. Yes, sir.
No. Work cannot be allotted to the director, nah. But what type of writ petition has been filed? On this ground only your writ petition should be dismissed. What is NEFS? To a company in the name and style of, what is the name of your company, madam? Huh?
No,
Your company.
Next.
NEFFS India Private Limited.
Now, what is the name of Fuller? To NEFFS India Private Limited.
Absolutely.
Pursuant thereto, the respondent, it is alleged in the petition that the respondent number 4 allotted certain works from the said contract entered into by and between the respondent number 2 and 4 No, the contract was entered into between NEFS with with them, na? By EPIL with you. So that is what EPIL is respond number 2.
2 and 5, man.
Mr. Samad,
Man.
you have done so many matters pertaining to civil matters and all. How are you making the general manager a party?
I was
This is
not
not
there.
the way how you make parties.
In 24, my entry was there. Prior to my entry, man, it was filed in 2014. I entered in this man in the year 2024. Man. This is only the
The
official.
materials on record from the brief facts of the instant case are that Brahmaputra Cracker and Polymer Limited, bracket BCPL, requested what is EPI's full form?
Engineering Projects India.
Engineering Projects India Limited, bracket EPIL, to carry out certain project works in respect to the gas cracker project of BCPL at Lapet Kota. EPI thereupon issued a notice inviting tender wherein NEFFS India Private Limited, bracketed short NEFFS, was granted a contract for completion of certain parts of the Lepetkata gas cracker project of BCPL. The same NEFFS with okay, that's not relevant. It is further relevant to take note of that NEFFS, which is a private limited company, granted a subcontract to the petitioner for carrying out certain works by then work order dated by the subcontract on 18/8/2010. While the petitioner was carrying out the same work, the NEFFS terminated the said contract and did not release an amount of rupees 1,81 lakhs for the work carried out by the petitioner. The petitioner thereupon initially approach any FFS for payment, and having not been received due favorable response, approach EPIN for payment of the amount of rupees 1 crore 81 lakhs by submitting representation the petitioner also submitted representation to the BCPN requesting for making payment of the amount to which the petitioner is entitled to. However, it is the not it is the knowledge the petitioner also had come to learn that the respondent number that EPI owes a huge certain amounts of money to NEFFS, and out of the said amount, the petitioner could be paid his dues to the tune of rupees 1 crore 81 lakhs. However, neither BCPN nor EPI took steps for releasing the said amount of rupees 1 crore 81 lakhs to the petitioner, for which the present petition. The record reveals that the respondent number it is record repeat that the respondent number 4, that is NEFFS Limited, who its director filed an affidavit in opposition challenging the maintainability of the petition on the ground that the dispute involved is a purely civil dispute. It was also mentioned that the respondent number 4 have been put to great difficulty on account of non-release of funds by the EPIA, thereby resulting in initiation of proceeding under the SURFACE Act. It is also mentioned that there is an arbitration proceedings going on between EPI, ECPL, and the petitioner and the and NEFFS. Paragraph 8. It was also mentioned . The respondent numbers 2 and 5 also filed an affidavit in opposition. Wherein it has been mentioned that on account of non-performance of work by the respondent by any FFS, the respondent number 2 and 5 terminated the contract on 15/3/2011. It was further mentioned that the respondent number 2 and 5 never and ever allotted any contract of work to the petitioner and has no privity to the arrangement held between the petitioner and the NEFFS. Let me come back. Hello. Yes, Mr. Sharma, very poorly drafted with. It was also stated that the petitioner, by way of the instant writ petition, had made an effort to make EPI liable for payment of certain unpaid and unverified bills arising out of a work order of the contract between the petitioner and NEFFS, to which EPIS were never a party. In addition to that, it was also mentioned that though certain payments were made directly by EPIL to the petitioner, but the same would not create any form of contract between the petitioner and the EPIL. The record further reveals that the petitioner filed an additional affidavit bringing on record certain checks which were being issued by EPI to the petitioner. Reply thereagainst have also been filed by the EPI. Stating inter alia that there is no contractual relationship between EPIL and the petitioner, and the said payment of rupees 40 lakh was made at the instruction upon instructions of the respondent number 4, that is NEFFS. Another affidavit has been filed. An affidavit has been filed by the respondent number 4. Wherein it An additional affidavit has been filed on behalf of the respondent number 4, wherein it was mentioned that on account of the non-payment of the dues by the respondent number 2 and respondent number 5, the respondent number 4 has faced various various proceedings in the courts of before various courts. In the backdrop of the above pleadings, this court duly heard the learned counsels appearing on behalf of the parties, and the submissions so made were in tune with the pleadings, and as such, this court, for the sake of brevity, is not repeating the same. Having heard the learned counsels appearing on behalf of the parties, and having also perused the materials on record, it is apparent that the petitioner do not have any contractual relationship with EPIL. The relationship, the contractual relation, if any, of the petitioner is against is with NEFFS. What the petitioner have tried to do by way of filing the present petition is on account of an purported breach of the contract by the respondent number by NEFFS for non-payment of certain dues. The petitioner seeks appropriate directions upon the EPIL, which for payment of the said dues. It is the opinion of this court that the extraordinary jurisdiction of this court under Article 226 of the Constitution cannot be permitted to convert a dispute which is purely civil between the petitioner and NEFFS to be converted into a public dispute, to be converted into a proceeding under Article 226 of the Constitution on the ground that EPIL owes certain money, on the alleged ground that EPIL owes certain money to NEFFS. This court also cannot be unmindful of the fact that there are also pending disputes between NEFFS and EPIL, which is presently under adjudication.
No, there is no dispute as such. There is no direct dispute. Some other respondents, other subcontractors have filed cases against.
No, arbitration?
Arbitration is over.
Arbitration over.
Yes. Arbitration was also between BCPL and EPL.
They were not a party. Now what is going on? Then what has happened? By PPSC, and you have not got any money.
No, my lord, I just give a break. I follow this because it is between the. My lord, this honorable court has taken all money to be paid to NEPS at the very first instance of the motion stage. But there was a TRT order also, which also said that the EPI should not pay to NEPS, but to be paid to PNB account because NEPS has become NPA. So we were at a situation where we didn't pay anything to anybody. Then I got the order modified. This honorable court has modified and say that only to the extent of rupees 90 lakhs, which is both the parties have agreed, that is to be kept on reserve. Then I am keeping it reserved. But in the meantime, that 90 lakhs, their settlement, once I paid the other person, keeping 90 lakhs, again dispute arising between them. Now they are disputing that 90 lakhs.
No, we are not disputing that.
So only 90 lakhs I am keeping it on.
It is also the opinion of this court as to what amount the petitioner, the respondent number, NEFS is entitled from the EPI are questions which are to be adjudicated in the proper forum. Under such circumstances, it is therefore the opinion of this court that this court cannot pass any direction or order in terms with the relief which have been sought for by the petitioner. Accordingly, this court does not find the present proceedings to be a proper proceedings for entertaining repetition, proper proceeding for exercise of jurisdiction under Article 2 to 6 of the Constitution, for which the petition stands dismissed. Be that as it may, before parting with the record, this court observed that taking into account that the petitioner have been bona fidely litigating before this court, the petitioner, before parting with the record, this court finds it very pertinent to observe that this court have held that the dispute between the petitioner and NEFFS is a purely civil dispute. Under such circumstances, purely civil dispute between two private parties. Under such circumstances, as this court have not entertained the instant writ petition, it would be entertain the instant writ petition, and the petitioners have also been bona fidely litigating before this court. The dismissal of the instant writ petition herein by this judgment shall not prejudice the petitioner to approach the competent court of civil jurisdiction, wherein disputes of private nature can be settled. In addition to that, the period during which the instant proceedings have been pending, that is from 25/2014 till date, be excluded while computing the period of limitation.
My lord. I want to submit one thing, my lord. So far, the role of the APL is concerned, my lord. When, my lord, it will be, my lord, the SPP is filed back, then APL will be exempted from the operation of the
What?
APL. But so far, that APL involvement in the contract party is concerned. What happened, my lord, we have carried out the work through, my lord, NAS for EPIL. So their liability is also there, which I may also raise in the civil suit.
You read.
That part, my lord, so far that observation will be
There is
given
no
because they will
contract.
be.
No, I am not going to. You produce everything. Here, from these materials, there is no contract between you and
No.
IEPL.
So far,
That
so
is
far
what
that
I
part
have
is-
observed.
I am not, my lord.
So there is no
disputing that.
privity of contract between EPL and you. And thereafter, what will happen? In fact, this is very
No,
poorly
that's too much.
done.
Lordship is right.
Item 11, fixed at 2 p.m.
Mr. SS Gustami, your matter. Where is the agriculture department?
My lord, my lord, certain clauses
Yes.
My lord.
Let us see the requirement of submission of the BIS certificate.
My lord.
The requirement of submission of the BIS certificate.
My lord, may kindly come to page 65.
Yes.
Section 5. The requirements.
Details of the requirement.
Serial number 2, my lord.
Huh?
Serial number 2. Agroplastic. Plastic mulching film 20-30 micron. UV stabilizer plastic mulching film. Color so and so. Thickness so and so. Micron as per CPAT report. Silver life 12 months product should conform to the specification as per IS 172162019. These are all important, my lord, because respondent number 5 and 6 has not fulfilled.
No, no, first you satisfy yourself. Let us see, forget
My
about
lord.
him.
This is, my lord, so far.
Where is the requirement of submission of the BS certificate?
My lord, it is at page 67. Serial number 2, my lord.
Quality standard.
Quality standards.
You are 25 to 30 micron.
Yes, my lord, 25 to 30 micron.
BIS valid
CPAT
report
test
and
report.
so and so,
Yes,
certain.
my lord.
And this is required to be submitted by where
At the time of submission of the tender, my lord.
is it meant?
Here I have one submission, my lord. There is a word BIS, comma, then valid CPAT test report. CPAT laboratory of Government of India has inspected my documents and given me the valid CPAT test report, but I did not apply for the BIS certificate, my lord. I submitted my tender with CPAT test report, and I have written a forwarding letter that I have already applied for BIS certificate, and BIS authority told me to requirement of at least 15 to 20 days time that may kindly be allowed. And that has been reflected in the DVC meeting. And they have allowed it till 27/8/2025. This is my case, my lord. I did not submit the BIS certificate at the time of filing of the tender. I was not rejected. I was considered, my application was considered.
You submitted the email only on 28
Email I have submitted on 28, my lord.
and the BIS certificate is 26/8.
26/8, my lord.
So they have considered on 27 on that date, they have given you time only till 14/8.
They have given me time till 27/8, my lord.
Where is that doc?
This is
Till
the,
27/8.
my lord, kindly come to page 113.
Yes.
113, serial number 2, my lord. I'm reading it, my lord. Non-submission of BIS license from OEM by Messrs. Kuberan. Messrs. Kuberan submitted bid for item mulching film so and so, but failed to submit the BIS license from OEM at the time of bid submission. The bidder has sought 15 to 20 days time for furnishing the bid license from OEM, while letter number nil dated 18/8/2025. But the bidder even fails to submit the same on the day of DBC meeting held on 27/8/2025.
That is okay. But where were you permitted that you are to submit? You have to submit as per 14/8. There is some mention in the affidavit. Kindly come to this affidavit, it has been mentioned here. Yeah. Next, 30. Take the next. Take the 2. So here you say on 14/8 that need another 15 to 20 days.
My lord, that was considered on 27, my lord.
But on 27 also you did not submit.
My lord, kindly see the affidavit in opposition, page 168.
168,
68, my lord.
160.
Yes.
160 there is no.
168, my lord, 168.
160. Yes.
My lord, last para of paragraph 8. Be it stated herein that. Kindly see. Be it stated herein that as per the email dated 28/8/2025, annexure 5 to the writ petition, it appears that the BIS certificate was issued on 26/8/2025 in the name of the original manufacturer, my lord. This is the admission, my lord.
So?
And this is an online, my lord, this 27 meeting.
No, you are you not required to submit the BIS certificate at the time of submission?
Yes,
Then matter over.
it is required, my lord.
Then
My lord, I am not agreed by that. I was happy had I was declared non-responsive for that. But respondent number 4 is made responsive for not submitting the turnover certificate, man. This is a mandatory document. Turnover
no,
certificate.
turnover certificate is
Not a
there's
historical
reason
document.
given here. They've given a
My
reason
lord,
why the
kindly-
turnover certificate has not been required.
My lord, kindly see the page 113, the technical evaluation, my lord. This is very important, my lord. I have read only paragraph 2, my lord.
We are concerned with the respondent number 4, na?
4, 5, and 6, my lord.
Okay, 4
Yeah, I have
is
been,
that the respondent number 4 submitted the turnover certificate from 2019 to 2020 to 2000. However, as per so and so as reflected in the question, turnover from 2020, 2021 and to the years to be submitted. The matter was discussed and decided that the turnover certificate is a historical document as per clause so and so of so and so. Yours is not a historical document. It did not exist
my lord,
as on the last date of submission.
my lord, I have not claimed, my lord, that this is the historical document. I have not claimed in my writ petition
So
that mine is historical
they
document.
have a good reason.
My
And this
case
is permitted as per 23.15. Where's
My-
the Assam procurement? 23.15.
yeah,
Let us see
it
historical
has been quoted, my lord.
23.15.
It has been quoted in the affidavit in opposition itself, my lord.
23.15.
My lord, page 175, it is, the rule is quoted. And I have the rules also. Page 175 of the affidavit in opposition. That page 175 rule is quoted.
Bidder may waive non-conformities in the bid that do not constitute a material deviation, and so and so may request the bidder to submit necessary information or documents which are historical in nature, the audited statement of accounts, tax clearance certificate, PAN, etc. within a time. Fails to comply with the request within the given time, the committee shall ascertain the term. So,
My lord, kindly see here, the turnover certificate is not mentioned, my lord.
what?
Question is turnover certificate.
Turnover certificate is to be given by them only. This is a, what is the certificate? Audited statement of accounts,
Accounts,
tax clearance certificate, PAN, etc. within a year. Then,
statement of accounts and the
so
turnover.
has the respond number 4 got anything?
Number 4 is not within the zone of the, he is not the L1.
He's L6.
Yeah.
Matter over. Then,
My lord, kindly see, I
and
am,
you are L2.
my lord,
You are L4.
I am L1, my lord.
No, you are not L1.
My lord,
No, sir, we have given the private statement of it.
Where? We are concerned with 20 to 30, na?
Yep.
20 to 30.
180.
20 to L1 is laser link.
He participated in serial number 2 and 6. 2 losses due to non submission of the BIS certificate. He was not responsible. In 6 losses,
He was L5.
yes, sir.
my lord, I have given, I have, my lord, kindly allow me to.
Show me where, which clause BIS certificate has to be given.
My lord, kindly see, I have given a copy, my lord, rule. I have filed it also by way of an affidavit in reply, my lord. Page
What?
239, affidavit in reply.
Ah.
239.
Yes.
Page 239, Roman 4, my lord. I'm reading it. Whether my lord has got it. The shortfall information or documents should be sought only in case of historical documents which pre-existed at the time of tender opening and which have not undergone change since then. This should be called only on the basis of recommendations of the tender committee. Example, audited statement of accounts, PAN card, GST registration certificate.
But, Mr., forget about respond number 4. We are concerned with laser lane. Whether laser lane is a party.
No, no, not a party man.
Oh, he only got, yeah, in the next one you cannot get. Matter of fact.
My
That
lord,
is not
my lord, my lord,
Mr. Goswami enough.
my lord, my case is not at all on, my lord, my case is not at all on,
No.
my lord, my
The
case is.
question is, I would have understood.
Yes.
The respondent number 4 has been given. So why should I go into unnecessary thing when the respondent number 4 is not there?
My lord,
Better save time for another
My lord-
useful litigation.
my lord,
Let me disperse.
my lord,
Enough.
my lord, the basis of my whole case is this, my lord, I am unfairly treated in the technical evaluation.
Goswami, you should be very
I may be-
happy with me.
I may be allowed to place the facts, my lord.
What fact?
From the
No,
ten-
but
from the tender, my lord.
first and foremost, you submitted for 2 bits. One is for plastic
Mulching
mulching film
and
20 to
vermibase.
30 micron.
Yes.
Number 6 is HDPE vermibase with shade.
Yes, my lord.
In respect to HDPE vermibase but with shade, it is being given to JK Commercial.
Right.
Is JK Commercial a party
Yes,
here?
yes.
Okay. Now, what is the problem with JK Commercial?
My lord, he has submitted the shipment certificate which has not been asked for in the tender. He has submitted something else, my lord. They have justified, wrong justification in the affidavit, whole affidavit, my lord. I have noted down the whole affidavit in the position is full of wrong statement. From their affidavit, my lord, kindly see what they wanted to show, my lord. Kindly see page.
Now, let us see the allegation as regards respond number 5. Respond number JK Commercial is
Yes.
respond number 5.
Yes, my lord.
Yes, what is the allegation against respond? In respect to HDPE vermibase with shade, what is your allegation?
My lord, may kindly see. From their affidavit in opposition, I am
Mr. Goswami, you have to come from your own case. Where is the case as regard respond number 5?
my lord, kindly come to page 195, my lord.
No. Where is your statement made in the writ petition as regard respond number 5?
My lord, for better understanding.
Para 13. Foregoing paragraph area would curtail and it is evident that any of the area who have been declared technically out of them response number 5 and 6 have submitted full test CPET report contrary to valid CPET. Test report as reflected in clause 5.3 quality. So and so. Therefore, said respond number 5 having submitted test report of 2021 and 22 which are outdated, most irrelevant to the context, not valid in much as BIS standards have been revised in the year 2020. It is their most respectfully submitted that the BIS norms have been thoroughly reviewed in the year 2024, implementing its valid. Thus, the 5.3 of the NIT has strictly made it clear that the CPET report to be valid. Thus, any CPET test report approved by us, the other technically responsive bidders prior to its review in 2024 cannot be accepted as valid CPET report as per specification so and so. In spite of that, those were declared technically responsive and parity with equal treatment has been denied the petitioner. It is the only allegation
My lord,
of the CPET
my lord,
report.
I have made all the allegations specific, my lord, in my additional affidavit. My lord has permitted.
No, paragraph 13 is the CPET report.
Shipment.
Only the CPET report. So your allegation as per the CPET report is that they have given some CPET report of 2021 and 22.
And the specification, not sought for in the NIT. It's different specification.
Understood. So they have given for 2021 and 22.
Yes, madam.
And further, this is being done in as much as the BIS standards have revised in the year 2024.
Madam.
Now let us see what is 5.3. 5.3 is where?
5.3, my lord.
Ah.
67 page. Read
65.
67, my lord.
Ah.
BIS valid CPET test report and catalog of original manufacturer.
Valid CPET report and catalog of original manufacturer.
My lord.
So this is for number 6. We are concerned with number 6. Number 1 and 2 has already gone for a 6. You have no business.
My,
We'll see only
my
number
lord,
6. No,
I have
no,
not made
no.
one submission so far responding 4 is concerned, my lord.
No.
4 has
This
not
I am
submitted the
going
bid
to look.
security
Let
at all.
us see what is the reply to paragraph 13. 13. Okay. The NIT program was prepared to the maximum participation so the competitive price can be seen from India prevailing in therefore prepared report of 2021 and 22 were in the case of Asia where compared to I think we dismiss. Rest, I think division bench.
My lord, kindly see.
No,
Kindly see, small submission, my lord. Kindly see, allow me to make a small submission, my lord.
small.
I am not on financial bid as on. I am on the technical bid, my lord. I have been unfairly treated.
No, whether it is a CPET report has been, CPET report, there is no mention. 2021-22. Show me a document which says that after 2021-22 cannot be taken into account as per paragraph 13 of your report.
My lord, may kindly see page 65. The
Yes.
specification is given. That specification is given. Particular specification.
What is the stipulation?
Roman 2.
Huh?
As per last specification as per IS 17216 into 2019. The one
IS 159072010.
IS 17216.
No, 216 is gone for a 6. No more 216. 216 you are out. You have not given the PI. Now I am concerned with this. Because there a person is have been held to be a technically responsive, and there is no allegation against him. So
My lord,
no.
I have one.
Feeling him has gone for a 6. Now come to that HCME Vermimet shit.
My lord, may
Where is it mentioned that it has to be the CPET report has to be in terms with
my lord, may
2021-22?
kindly come to page 172. Affidavit in opposition.
Yes.
They have endorsed this document is super respondent of 5 is concerned. Now top top of it, my lord, whom it has been issued. It has
Page 1,
page 195,
90.
195.
Yes.
To whom it has been issued. This has not been issued to the manufacturer of the respond number 5.
This is for part only.
My lord.
Page 195 is for part only.
Okay.
Mr. Council, kindly look at page 173, what is written. Kindly see it down below. Paragraph 14 down below. The short submission has become too long. Think it.
In case of Mulsing film,
We are not concerned with Mulching Film. Here, yes, Mulching Film CP report
test
of
report
the
of submitted by respondent
number
of
5, so and so.
were compared with CPA test report submitted by another responsive bidder, my lord.
Yeah, and found that these parameters such as so and so, so and so, so and so area that accepted by the bid evaluation committee are enclosed herewith and marked as Annexure 4. Now kindly see, in the case of either by pay, respondent number 6 submitted 2 test reports, being test report number so and so, in which the test values are found within the acceptable range for major parameters for so and so.
My lord, kindly my submission is see, my lord, whether the tendering authority is the expert of the CPA laboratory engineers.
I am not.
Tendering authority.
Mr. I think division bit. Heard Mr. S.S. Usami, the learned counsel appearing on behalf of the petitioner. Mr. P. Chaudhary, the learned standing counsel of the agriculture department, appears on behalf of the respondent numbers 1, 2, and 3. Mr. Plan appears on behalf of the respondent number 4, 5, and 6. In spite of notice having been effective. The petitioner herein have challenged the petitioner herein have sought for a mandamus, thereby directing the respondents to accept the BIS license, which have been approved uploaded on 26/8/2025 prior to the bid committee meeting dated 27/8/2025. An online and hard copy of which was submitted by the petitioner on 28/8/2025, giving parity as have been done in respect to the respondent number 4, and declared the petitioner technically responsive. The petitioner have also sought for a writ in the nature of tertiary for setting aside and quashing the NIT dated 17/6/2025, being in derogation of the mandatory NIT clauses which the responsive bidders have failed to fulfill. Full stop. It is shorn of unnecessary facts, unnecessary detail. It is pertinent to mention. It is pertinent to take note of that the Directorate of Horticulture and Food Processing Assam had issued a bid document, had issued a notice inviting bid for procurement of goods and incidental services as specified in section Roman 5 dash schedule of requirement of the bid document. Full stop. In terms with the paid notice inviting tender dated 17/6/2025, it has been mentioned that the bids must be submitted online at the e-procurement portal, that is http://assamtenders.gov.in on or before the due date for submission, that is 11/7/2025 up to 5:30 p.m. It was also mentioned that the bidders were also required to submit the hard copy of the technical bid bracket with original document bracket close in the office of the procuring entity within due date for submission of the within due date for submission of the hard copy of the technical bid, that is 14/7/2025 up to 5:30 p.m. It was also mentioned that the technical bid would be opened online on 15/7/2025 at 11:30 a.m. and the prize bid shall be opened online only for technically qualified bidders. Full stop. Sections Roman 5 of the said bid document stipulates the schedule of requirements. Full stop. In the instant case, the petitioner have submitted bids in respect to two items, namely plastic mulching film bracket 20-30 micron and HDP vermibed with shade. The same are listed at serial number 2 and 6 of clause 5.1 of section 5 of the bid document. Taking into account its relevance, the same is reproduced. The said item, the details mentioned in clause 5.1 insofar as the items at serial number 2 and 6 are reproduced hereunder, page 65 or 66. The quality of the items have also been mentioned in clause 5.3 of section Roman 5, as well as how the said quality shall be evaluated by standards oblique certification. In respect to the item at serial number 2 of clause 5.1 above quoted, which is plastic mulching film bracket 25-30 micron. The certification required are DIS, valid CIPT test report and catalog of the original manufacturer. In respect to the item at serial number 6, that is serial number 6 of clause 5.1, that is HDPE vermibed with shade. The standards oblique certification required are BIS, valid CIPT report and catalog of original manufacturer. The petitioner submitted the bid where's the corrigendum?
Corrigendum is enclosed in the affidavit, my lord. Affidavit information.
It is relevant to take note of that pursuant to the said notice inviting tender, a corrigendum was issued.
Seventeen seven 2025.
Whereby some of the clause of the tender document were amended. The state corrigendum was issued on, what is the date?
17/7/25.
No. What is the date? Can't be 17/7. Is it 17/7?
In the first line, is it bid committee.
In pursuance to the decision taken in the bid held on 17/7.
Yes, ma'am.
What is the date of the corrigendum? Huh? That I also know. No, because this happened after the technical bid was made, nah? Where is that, yeah, it has been extended? It is further seen from the materials on record. The two corrigendums were issued, being corrigendum number 1 and corrigendum number 2. Pursuant to the departmental bid committee meeting held on 17/7/2025. Wherein the annual turnover, which was originally published at 30%, was reduced to 20%. And relevant for the purpose of the present dispute is the amendment to clause 5.3. In the original tender, clause 5.3 read as documents, documents sought for from the bidders are BIS, valid CIPT report, and catalog of the original manufacturer in the case of shade net 75% and 50%, weed net, crop support net and insect net. And it was amended as documents sought for from the bidder are inverted comma documents sought for are BIS, valid CIPT report, oblique SASMIRA report, SASMIRA, all caps, report, and catalog of the original manufacturers in the case of shade. I don't think this 5.3 has any relevance for this. Yeah.
My lord, 4.2.2, whereby 3 years has been extended to 5 years, my lord, turnover.
Now, this is also not relevant. We are concerned with the BIS only.
No, this is relevant, my lord. This is relevant, my lord.
Why?
Because respondent number 4 did not submit it the 5 years. He submitted only for 3 years. Subsequently,
Respond number 4, I'll take care of that. Don't worry with that. So they have amended. No, okay. Whereby the annual turnover was increased. I was decreased at 30% to 50%. In further to that, various clauses of the original notice inviting tenders were amended, that is clause 5.3, clause 4.2.2, clause 4.2.2, clause 4.2.2, and clause 5.1, clause 5.1, and clause ITB 2.20.1. In terms with the amendment at serial number 3 of the corrigendum, which pertains to the required minimum experience, the original tender clause stipulated as under page 189 of the post amendment by the corrigendum is reads as under. Pre-corrigendum. Pre-corrigendum. In corrigendum number 1, corrigendum number 2. It is also stated at the bar that the last date for submission of the bid, online bid, was extended to 14/8/2025 at 5:30, na?
Yes, ma'am. That's what I have. It was extended till 5:30.
5:30 p.m.
Yeah.
And the technical online bid was to be opened on
Lordship 18/8.
18/8/2025. The petitioner thereupon submitted the bid for the items listed at serial number 2 and serial number 6 of clause 5.1. And admittedly, the petitioner did not submit the BIS certificate. Rather, on 14/8/2025, which is the petitioner submitted a request by the communication to the Director of Horticulture and FP, Assam, stating inter alia that the BIS license of the plastic mulching film as per quality standard clause number 5.3, the petitioner undertook that the petitioner would submit the BIS license for IS 17216/2019 of its manufacturer Impero polyflips within 15-20 days by email and hard copy also. The petitioner also enclosed an undertaking from the manufacturer along with tax invoice of the license fee, inspection charge, etc. from the BIS for time perusal. It was also mentioned in the said communication that as regards the work experience mentioned in the corrigendum of the departmental bid committee meeting held on 17/7/2025, uploaded on 29/7/2025, at serial number 3, clause number 4.2.2 of the bid document. The petitioner have submitted the work experience of mulching film to the department, comprising of the last 5 years alongside copy of the satisfactory work completion certificate. And this particular certificate is also relied on for item number at serial number 2 and serial number 6 of clause 5.1 of section 5. Also, pursuant thereto, the petitioner issued another communication on 18/8/2025 to the Director of Horticulture and FP, thereby requesting for acceptance of the bid in view of the BS license being under process. In response to the participated item mulching film, on 27/8/2025, the departmental committee took up the technical bid for evaluation. On the ground that the EIS license from the OEM was not submitted by the petitioner for the item mulching film -20-30 micron. At the time of submission of the bid, it was held that the bid so submitted by the petitioner in respect to mulching film 20-30 micron was non-responsive. This court also finds it pertinent to take note of that in respect to the respondent number 4, as the CA's respondent number 4, liberty was granted to the respondent number 4 to submit the CA certified turnover certificate for 2019-20 to 2024-25. That is for the last 6 years, as it is a historical document. The petitioner thereupon, on 28/8/2025, after the decision taken on 27/8/2025 to hold the petitioner technically non-responsive in respect to mulching film, in respect to the item mulching film 20-30 micron, submitted a an email along with the BIS certificate dated 26/8/2025 for due consideration. The same was not considered, for which the petitioner had approached this court by filing the present petition. Petitioner had also filed an additional affidavit wherein
In the last page, my lord, I have given the last annexure, my lord. I have given the details of deviation. Page 161. Comparative statement.
the various certification issued to the original manufacturer of the petitioner were enclosed. The financial evaluation meeting minutes have been enclosed, as well as a comparative chart of deviation pertaining to respondent number 4, 5, and 6 from the NI. The respondents have also filed an affidavit in opposition. The respondent number 3 had filed a detailed affidavit in opposition. It is interesting to take note of that in the said affidavit in opposition, the comparative chart pertaining to the various items mentioned in section 5 of the bid document have been enclosed. In respect to the plastic mulching film, bracket 20 to 30 micron, for which the petitioner had submitted the bid and did not submit the BIS certification, admitted on the date on which the bid was required to be submitted. One lazily which is not a party to the instant proceedings, have been found to be the lowest bidder. contract granted? And it is also being submitted by Mr. B. Chaudhary that the contract have also been issued. This aspect is pertinent taking into account that the allegation of parity of treatment which the petitioner seeks is vis-a-vis the petitioner and the respondent number 4, 5, and 6. Here, 5 and 6 is there, not there. JK is not there, or JK is there. 4, 5, and 6. However, there is no allegation against Laser Lane, who is the L1 bidder and have been duly granted the contract. The materials on record categorically show that the petitioner did not submit the BIS certificate of its original manufacturer till 28/8/2025, that is after the technical bid evaluation was carried out, not to speak of on the date on which it was required to be submitted, that is on 14/8/2025. This court does not find it necessary, therefore, to deal with the allegations so made insofar as the parity of treatment as regards respondent number 4, 5, and 6 in respect to the item number 2. That is for supply of the item plastic mulching film. The question therefore arises is as to whether there has been a violation of the equality clause insofar as the treatment meted out to the petitioner, insofar as the item at serial number 6 HDP Vermibed with shade, wherein the respondent number 5 have been granted the contract as it is the L1 bidder. It is not out of place also to take note of from the comparative sheet chart that the petitioner is at L5, whereas the respondent number 5 is L1, followed by one Krishna Enterprise, L2, Gujarat Craft Industries, L3, Colosor Agro Service, L4, the petitioner, L5, and the respondent number 4, L6. Okay, I dismiss your petition. I'll come back. I'll not come back because I'm rising.
My lord, only one submission. My lord may consider or may not consider, my lord, only for my satisfaction, that there is advisory I have enclosed, advisory of the finance department I have enclosed, my lord. A copy was also given in the last date, in which it has been stated that this particular turnover certificate is not a historical document.
That is only the allegation is against respondent number 4.
My lord.
And respondent number 4 in respect to that, respondent number 4 has not got it.
My lord.
Why you are on that? Therefore, it is not required. Because here it has been given to Laser Lane. So we are not concerned. Laser Lane is not a party out here. You have not asked that there is no parity of treatment against. But as regards this, we are therefore seeing that you are asking for this very fine distinction of the chief CPET and all this thing. Yes, Mr. Mahmood, your matter was at the top of the list. Yes, they have Miss Bhuiyan. Because of you, we could not take up this matter. It's a very urgent matter.
Lordship,
You know, you say, isn't it fixed at 10:30? Matter was fixed at 10:30.
So sorry.
Maybe they're in court number 2. If you don't have that, next time we are having this tomorrow at 10:30 AM.
I've
Earlier.
seen, I have gone through.
I'm not concerned. We are having it tomorrow at 10:30.
Whether it was violated, that's the,
Mr. Mahmood, tomorrow I'm taking it at 10:30 AM.
even if there are motion matters, my lord, your lordship will take up it.
I'm taking it as the first item.
Yes.
10:30 court seats
Yes.
first.
Yes.
This the matter at 10:30 AM.
I'm so sorry, lordship, for the inconvenience.
My lord, item number 7 may be taken up next week. This week I will be little out of station.
It won't come next.
Any date your lordship thinks can.
Yeah, get your dates. Available. Your matter is there, na?
Item 7 or